Good morning.
Good morning. So Kit or Barbara? The view that I have is just you folks, and then Kit's and Barbara's screens as well, and that's the only view that I have. Should I see other participants?
No, nobody else is in yet.
Really? At 8:28?
Yeah. Wait, you guys have to mute because that is a microphone. Good. Absolutely. Try again. Now. Okay.
Good.
That's
And then thing
You haven't
two,
let the people in from the waiting room yet, Jeff.
okay. And thing two, if you obviously, if you pre-prepared a mileage sheet for me, don't let that get filed reflecting
No.
that I drove down there when I didn't. So
I've got it right here unsigned.
I honest to God thought you were calling us thing one and thing two.
I know.
hey, thing two. I don't mean to be insulting, but hey, thing one.
I was just trying to figure out which one I was in this scenario.
That would really be really insulting, I think.
I need to drink more of this.
I'm gonna let the waiting room in.
Well, 6 cases, you're always right on the edge.
Yeah.
Anybody making children's hungry, so get yourself some lunch.
So we're doing this?
Yeah.
Okay, of
We
course.
seem to, we're on a run of having hearing agendas of
Yeah.
6 cases every single time, which is about the limit we could do without breaking for
Right.
lunch.
Yeah.
So I just want to make sure that you're all set.
And if you.
Thank
Complicated.
These cases today are.
Never
Some
goes
of them,
anywhere.
No, no, trust
So,
me.
A pad, a pen that writes,
So people get
hopefully
their
their
heads
voice works. And if those don't work, you just stay home.
Stay on that, yeah.
We ready?
Take it home.
Yes,
Good morning. I'm Jeff Ashby. I'm here on the screen, not in person there in Augusta. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed to the business of today, I am asking each of you who may have an electronic device with you to ensure that they are silenced. We have additional agendas, including the consent agenda, available. I believe it's been made available electronically, and it's available there in Augusta in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. My laptop just shut down on me, but I think we consider the consent agenda first, folks, and approve the agenda.
Okay, do you want me to shut this?
Yes.
Yes, first, yeah.
Yeah, we're going to adopt the agenda and consent agenda minutes. I'm sorry, and consent agenda, and I'm looking for a motion.
before we do the motion, I just want to make sure everybody knows our remote participation policy requires me to make sure that the commissioners' votes can be both seen and heard. So I'll be polling the commissioners who will signify their vote both orally and visually. A motion to adopt the agenda and consent agenda.
So moved.
Second.
Okay, it's been moved and seconded. Any discussion? Seeing none, if you vote yes, you are in agreement. Commissioner Ashby.
I'm going to abstain.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
All right.
All right, and then we'll entertain a motion to approve the October 2023 commission meeting minutes.
So move.
Second.
Okay, it's been moved and seconded. Any discussion? Seeing none, Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Great.
And next is Kit's director's report.
So many reports for you today.
Yes, I was impressed. That was a
This
lot.
is- Yeah, we have our usual memos, which I'll go through, and then we have our quarterly reports. So you have a memo for me on personnel stating that we have no developments in personnel. Hopefully we'll have a different answer for you next meeting. Our job postings for Director of Operations, Business Manager, and another investigator position have closed, and I'm just waiting to get those applications so we can start scheduling interviews. Conciliation memo purporting to be from me, but actually from Jane. We have, my goodness, 7 cases in active conciliation. 2 unsuccessful conciliations, 3 successful conciliations, and I have 3 agreements for you to approve in E20-0544, E21-0317A and B, and E21-0347. So I need a motion to approve those agreements.
So move.
Lee? Second?
Second.
Moved and seconded. Any discussion? Seeing none. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Great. Thank you very much. Okay, and case inventory. Okay. So we have had 40 new cases filed in October.
What do you want, Kim?
The,
Pending inventory?
yes, pending inventory. So 40 new cases. We have had, sorry, my glasses just fogged up. 5 administrative dismissals, 5 right to sues, 2 successful mediations, and 7 cases that withdrew with benefits for a total of $167,500 to complainants in those cases. We talked about the litigation, and we'll take litigation in executive session. That's all right with you. All right, quarterly reports. We've done the pending, so we have, oh my goodness. 625 pending charges currently at the commission with an average age of 302 days, which is pretty good for us. That's less than a year old with our 2-year statute. That puts us in a pretty solid position. And you also have a finance memo, and I'm just gonna say, this is the first one of these that I have done. Our budget analyst left about a month after I took over and has gone to a different agency. I've got 2 lovely, very knowledgeable temporary guys assigned to us, but if you have questions about this, please email me and I will ask them for the answers because I'm still learning how to read this one. But here it is. There's your quarterly. This is a finance report for the first quarter, which is July through October.
I would just like to say that even getting these reports from these people is quite the job, so read it.
You also have our memo on quarterly training and education, wherein you can see that I spent my summer going to endless conferences. So did Barbara. And there's also, I think I sent you all the email about this. In December, we will be holding the fair housing training webinar that Jane hosts, which is a recording of a webinar of a presentation by Amy and Patricia Ender and Carrie McCarter. We will update it. We have a grant from HUD to update that one. But if any of you would like to attend, I think I've sent you the link. I know a couple of you had asked some questions about the fair housing stuff, so you're welcome to do that. Unfortunately, Ed, I cannot give you CLE credit for it yet, but maybe we'll be able to do one with the with this new grant.
This is on the 5th, correct?
It's on the 5th, yep. All right, so I think those are all the reports I have for you. Any questions about any of those? I try not to drown you in these. The only new business I have is that the legislation that we proposed, that I think we talked to you all about a couple of meetings ago, now has sponsors. Nothing else has happened with that. We will keep you posted. Any questions? Anything?
I had a question, and I'm not sure exactly which one of these financial reports was. What is Lighthouse Consulting?
Lighthouse Consulting is the firm that we hired to build our internal database. So we have an internal database that we use to track all of our cases. And the investigators use it, and the hope is soon it will be open to the public so parties can submit things online and keep track of their cases online. So that those invoices are Brian Shaughnessy doing work on that.
On the inventory charge age, that number came down considerably from the last report, didn't it?
We've been really pushing to get the cases wrapped up, and so yeah, it's possible that we've made some big progress on that. The investigators are working incredibly hard right now.
Can we, I don't encourage you to do this, and I'm wondering if it's a function of that, but do we change the charge age by moving cases along without an investigation? Like right to sue letters and that sort of thing?
And mediations, to an extent, yeah, that does impact the charge age. And I have been pretty diligent about reviewing cases and getting them to mediation. So we've had an uptick in getting cases through that process. I think our settlement rate through mediation is still about the same, which is, I think, about 30 or 40%. But a lot more of them have been moving.
Is the average staff age a better tool to determine how fast and how efficient we are getting investigations done?
I think the staff age is about the same, isn't it?
It is, it's within a day. Yeah.
300, yeah. No, I think it's just a reflection of, we have a really good team of investigators who have all been here for a while and are working really hard to move their cases on.
Well, that was certainly my impression from the numbers. I was hoping that was the case, as opposed to, say, not investigating them and kicking them along through another means.
No, we are doing, they've got quite a caseload. And I mean, I am also trying to move along the mediation cases and write to sue letters and get those out and closed, just so cases aren't hanging around too long.
Fantastic.
Yeah.
All right, well, we have 4 minutes.
Great.
Thank you, Kit.
I don't know how this stuff works.
Okay. If we're ready, The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or identified here on screen to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you come to the podium or are recognized. Thank you. And the first case today on the agenda is E21-0474. That's Adam Shapiro versus Chimbro Corp. This is a no reasonable grounds case, and as a result, we will hear from the complainant or his representative.
I'd like to remind everyone participating today to please not use the names of third parties. In our reports, we've given them pseudonyms, and the Maine Human Rights Act requires the commission to maintain their confidentiality, so we're asking those presenting here to do the same. Attorney Young.
Thank you. Thank you. Good morning, Chairman Ashby and members of the commission. My name is Jeffrey Neal Young, and I represent Adam Shapiro in this claim for violation of the Whistleblowers Protection Act. Mr. Shapiro is here this morning by Zoom. I'd like to reserve 2 minutes for rebuttal. In evaluating Mr. Shapiro's claim for whistleblower retaliation, I'd like you to keep this thought in mind. Every time that Adam Shapiro raised a safety concern at Chimbro, his employer disciplined him soon thereafter. Most importantly, he was fired the very next day after he called an all-stop because of admittedly unsafe conditions on a barge, which delayed but did not prevent moving the barge across the Piscataqua River. The facts in this matter are largely, but not entirely, undisputed. Adam began working for Chimbro in August 2020, moving barges, carrying material from Portsmouth, New Hampshire to a project at the Portsmouth Naval Shipyard in Kittery, Maine. The investigator's report fails to mention that in February 2021, just a few months before he was fired, Chimbro gave him an excellent evaluation. The project superintendent, Mr. C, stated, quote, Adam has been a great asset to this team. He has a good understanding of the job and all the tasks at hand. Mr. Shapiro received a 5, the highest score possible for his safety and attitude. 1 month later, Chimbro gave Adam a substantial raise. Despite this, some 2 short months later, Chimbro fired Adam Shapiro. Did his attitude change? No. Did his concern about safety change? No. What changed was that Adam began to complain about unsafe working conditions on the barges. Adam first complained about safety on March 21, 2002 to Superintendent C and immediate supervisor L after he got entangled in lines on the barge, which had wrapped around his harness. In early March, Chimbro had ordered employees to wear harnesses when working 6 feet above the water line. Prior to that, employees had not always been doing so. While in general, this policy was a good safety practice, requiring employees to wear a harness was unsafe when employees were handling lines, as evidenced by what happened to Adam. The very next day after Adam expressed his concerns about having gotten entangled in the lines while wearing a harness, Chinbro retaliated for the first time by transferring him on a temporary basis to another crew and replacing him with an untrained team member. The investigator erroneously claims that Chinbro promptly remedied the safety hazard. While it is true that the safety director visited the work site several days after Adam complained, the situation was not fully addressed until May 10, 2022, the day before Adam was fired, and only after Adam continued to press for the situation to be corrected. Contrary to the investigator, while Chinbro did prepare a job hazard analysis, or JHA, dated March 26, 2022, revising the harness requirement, that JHA was not released on March 26, 2022. Rather, it wasn't released until May 6, 2022, and only after Adam continued to press the safety director for a response. Equally important, the JHA and 2 new safety standard operating procedures were not concurrently provided to the foreman. That did not occur until the day before Adam was fired, and only after Adam got permission from the safety director to circulate the new policy. It was Adam, not the safety director, who circulated the policy. In the interim between Adam's initial complaint about the harness policy, Adam raised several other safety concerns. Principal among those concerns was that walkways on the barges were being blocked by crushed stone or aggregate and nonetheless allowed to cross the river. While the walkways were blocked, Adam named the supervisors on what's called a tap card, including the superintendent and his immediate supervisor, prompting the immediate supervisor to threaten to fire Adam. 1 week before he was fired, Adam again named the 2 supervisors as having endangered safety by failing to add fuel filters to the barges, causing the engines on the barges to cut out, prompting the supervisor to storm off. Let me turn now to Adam's last day at work. Despite his prior complaints, once again, the aggregate was impeding the walkways on the barge. This time, Adam called an all-stop, preventing the barge from leaving the pier in Portsmouth until the aggregate was cleared. Chinbro and the investigator fault Adam for doing so, claiming that he waited until the 11th hour and that he had to be ordered several times by the superintendent to assist in clearing the barge. Neither of these arguments is accurate. Mr. Shapiro did not sit idly by, refusing to remove crushed stone or wait until the last minute to call the all-stop. Rather, throughout the entire period, he was working to build a barrier to prevent the crushed stone from spilling onto the walkways, while an excavator was removing the stone. Both sides of the barge needed to be cleared. Only after the excavator finished its work could the stone be shoveled and swept, including clearing stone which was covering the lines holding the boat to the pier so that the barge could depart. Adam was actively clearing one side of the boat when the superintendent ordered him to clear the other side. While he did initially protest that both sides needed to be cleared, he did eventually, as ordered, finish clearing the side that he had been working on later, and the barge crossed the river as needed. The very next day, Chinbro terminated Adam Shapiro. No progressive discipline. Adam contends that these largely undisputed facts support a finding of reasonable grounds. Under the MHRA, if it is equally likely that an employer violated the act as not, then the employee is entitled to a reasonable grounds finding. Here, virtually every time Adam raised a safety concern, Chinbro retaliated. It removed him from his job the day after he expressed concern about the harness policy. It threatened to fire him after identified the 2 supervisors is responsible for failing to add the fuel filters, which were causing the engines to cut out. And it fired him the day after he had finally pressed and gotten issuance of the new safety policy about the harnesses and had to request permission to disseminate the policy. Until Adam raised these concerns, as evidenced by his evaluation, he was a valued employee whose attitude was considered to be the highest possible.
Attorney Young,
After he raised the safety concerns, I'll
That's
wrap
your
up,
8
he
minutes.
became persona non grata. For these reasons, MHRC should conclude that he was terminated in violation of the Whistleblower Act. Thank you.
I have about 2 minutes when we come back to you. Questions for Attorney Young? Commissioner Ashby.
Thank you. Attorney Young, good morning.
Good morning.
So with respect to the complaint raised on March 21, 2021, you have represented, and I know the complainant claims that he was was moved to a different assignment the next day in retaliation. The investigator found in footnote 4 on page 5 references something quite different, that apparently there was a discussion with a foreman about Mr. Shapiro's safety concerns. The foreman gave him an option to join another crew, and ultimately the complainant decided to stay where he was. I mean, that's a pretty significant factual dispute. Can you address that?
Yeah, my understanding of what Mr. Shapiro has contended throughout is there wasn't any option to move from one to either stay with his crew or move to another crew. Rather, he was simply by, I'll call it fiat or by order, moved to another crew. So we dispute that.
So he did in fact move to a different crew. He didn't, as the footnote.
Yes, he did not.
He did not stay with the crew.
No, I'm sorry if I interrupted you, Chairman Ashby. No, he did not wind up working on his usual crew that day. He wound up working on a different crew, which was not the crew moving the barges that day.
Okay, all right, thank you.
Any other questions for Attorney Young? Commissioner David.
Good morning, Attorney Young. You said that there
Good
was
morning, Chair.
you said there was no progressive discipline, yet there's reference here to at least 2 counseling reports. I guess the second one is the one that results in termination. Is that correct?
There was a prior warning, yes, and then the second one was a termination. But when I said that there was no progressive discipline, in a general progressive discipline policy for something like this, one would not move immediately to a termination. One would have expected either another warning or some type of suspension.
Is the harness policy the requirement to be wearing the harness in effect at the end of his employment the day before when they're clearing stone off the walkways?
I'm not sure that the record reflects that, but but my understanding is yes.
And does the record indicate whether he was wearing the harness?
I don't think there's any dispute about whether he was wearing a harness that day or not. The issue was that the supervisor wanted him to clear the other side of the barge.
No dispute, meaning that he was following the policy and wearing the harness?
Yes.
Okay. It seemed to me that this came down to whether or not the alleged insubordination was for refusal to wear the harness, or whether the insubordination was because of a direction not to report safety violations. The latter would clearly be discrimination. The former would be the employer's prerogative to create the policy. How do you react to that?
I agree that the employer has the right to create the policy, but the issue on the issues with and Adam obeyed that policy after it was issued. The problem, I think, was the number of safety complaints that he made. And as I said on the last day, I do not believe there was any issue about his wearing a harness. It had to do with clearing the aggregate on the walkways. I hope that answered your question, Commissioner.
It does, but my other observation is it does seem as though Chimbrow has that the respondent has a concern for safety and has policies in effect to report concerns, to allow all stops to be called by anybody at any point. And yet you're saying that he's being retaliated for reporting safety concerns, right? Or not? You're saying he's
yes,
being
there are.
for, yeah, go ahead.
I apologize if I interrupted you. Yes, there certainly are policies on paper with regard to safety. However, as I indicated in my response, those policies are similar to an employer having policies which says that we won't discriminate on the basis of race, age, sex, religion, national origin, etc. That just because an employer has a policy doesn't mean that it is necessarily always following that policy. And we maintain that what happened here was that after the numerous safety complaints, Mr. Chimbrow regarded Adam's attitude as having changed from the evaluation just a short period earlier and terminated him.
Commissioner Douglas.
Yeah, good morning, Attorney Young.
Good morning.
I just wanted to ask you about the donut shop incident on April 8th. Just looking at the report, it says that complainant left the job site to go to a local donut shop without informing his supervisor, and then argued with his supervisor when told that it was impermissible to leave work without informing someone. So not a safety concern, but the report generally concludes that your client was terminated for insubordination. So I'm just wondering what your response is to that section of the report. I mean, are we claiming that it was permissible for him to leave work? Are we claiming that he did not argue when he returned? Give me your position on that, please.
Sure. With regard to the donut shop incident, Mr. Shapiro, and this is in the record, had been asked by the supervisor the day before to go to the donut shop and pick up donuts for everyone. On the day in question, the workers were waiting around, I believe, for some kind of contractor to appear at the job. And so they were basically standing around without having anything to do. It is true that Mr. Shapiro went to the donut shop on that day while there was nothing to do, and his co-workers were aware of that fact. Perhaps, candidly, it maybe wasn't the best exercise of judgment, but he had done so at the supervisor's direction just the prior day and thought that it was okay to do so again since they were waiting around for the contractor to appear.
Thank you.
Any other
You're
questions
welcome.
for Attorney Young? Seeing none, Attorney Young, you'll have 2 minutes when we come back to you. Pattern.
Thank you.
Would you like to reserve any of your time?
Yes, can I have a 2-minute warning? Good morning. My name is Melody Tavern, and I'm here on behalf of Chimbro. Dan Coffey from Chimbro is also with us via Zoom. And I'm going to talk really quickly because I have a lot to say in a short period of time, so please bear with me. In his complaint of discrimination, complainant alleges that he raised safety concerns related to his work as a deckhand at Chimbro, that he was criticized and then just discharged in retaliation for raising these concerns. Contrary to complainant's allegations, Chimbro never took any adverse action against complainant related to any issues or concerns raised about safety. Chimbro takes safety very seriously and actively encourages and expects team members to raise workplace safety concerns. The evidence demonstrates that Chimbro appropriately addressed all safety-related issues. During the course of complainant's employment, his performance and attitude declined significantly. He was given repeated counseling and issued a written warning for failure to follow direction from supervisors, failing or refusing to perform his job duties, and absent from the work site without permission. Finally, on May 11th of 2021, complainant blatantly and repeatedly refused instructions from the supervisor to perform a critical task that would allow work on the job site to continue. For these reasons alone, and with no relation whatsoever to safety issues, Chimbro made the decision to terminate complainant's employment. Chimbro respectfully requests that the Maine Human Rights Commission dismiss complainant's complaint of discrimination with the finding of no probable cause. Chimbro has developed its own behavioral-based safety process known as Chimbro Accident Prevention Process, otherwise known as CAP. It is not a program to report safety violations. CAP is a positive, proactive, team member-driven process that improves safety by reducing at-risk behavior. It is often referred to as no name, no blame. There's absolutely no retaliation or adverse action taken when team members submit CAP cards. To the contrary, it's considered a job expectation. Employees are expected to file them on a monthly basis. In addition, all Chimbro team members are authorized and obligated to pause work on a job site, known as calling it all stop, whenever they believe a safety risk exists. This obligation is set forth in the team member handbook. On August 24th of 2020, Chimbro hired complainant as a deckhand on the Superflood project at Portsmouth Naval Shipyard. Although complainant had previous experience working on private yachts and lobster boats, this position was his first experience working on commercial boats. Initially, complainant's job performance was acceptable. Over time, however, his performance and attitude declined significantly. Frequently, complainant failed to listen to direction from the supervisors, was unnecessarily argumentative, and avoided or refused to perform his job duties. Complainant expressed frustration about his position as a deckhand and believed that he should have been promoted to a boat operator when the position opened up, even though he was not qualified for that position because he lacked the requisite Coast Guard license. Complainant's allegation that he was criticized for submitting CAP cards was false. To the contrary, complainant was encouraged to submit CAP cards and did so throughout his employment. However, Chimbro has no record of receiving the alleged CAP cards identified in the complainant's complaint. They received others, but not the ones identified in the complaint. On February 22nd of 2021, Chimbro's Assistant Director of Safety visited the Superflood project and met with representatives from the Navy. Following the meeting, the Assistant Director of Safety scheduled a routine safety x-ray of the project from March 1 to 5 of 2021. In the course of the safety x-ray, the Assistant Director of Health noted issues with fall protection on 2 barges used by the barge crew. Pursuant to OSHA standards for construction sites, use of fall protection is required when the work surface is elevated 6 feet or higher above the lower levels, and that includes water. Members of the barge crew, including complainant, initially expressed concern that the fall protection created additional safety risks related to handling lines on the deck. During the week of March 22nd, 2021, the Assistant Director of Safety met in person with the entire barge crew to discuss their concerns and develop a plan to address them. Based on ideas generated during this session, the Assistant Director of Safety and the barge crew developed a tow-ready checklist, a set of standard operating procedures, and a job hazard analysis specific to line handling. On March 25th, 2021, Chimbro prepared, approved, and circulated the job hazard analysis for line handling, not March 10th, as the complainant suggests. Due to the nature of their work, the barge crew members are expected to remain on the job site during their shift and to notify their supervisors before departing for a work break. On one particular occasion, the complainant left the job site and had lunch without notifying the boat operator foreman or any other barge crew member. The boat operator foreman did not issue a written warning to complainant for this incident, but instead instructed complainant that he must not leave the job site without notifying his supervisor and obtaining permission. Thereafter, on April 8th of 2021, the boat operator foreman was unable to find complainant at one point during the workday. The boat operator foreman was very concerned that the complainant may have fallen in the water. boat operator foreman attempted to call complainant on his radio, but received no response. Complainant was missing for approximately an hour. When complainant returned to the job site, the boat operator foreman discovered the complainant had been at Dunkin' Donuts without notifying the supervisor or anyone else. Complainant was given a written warning for this incident, but refused to sign it. On May 11th of 2021, complainant was the only deckhand working on board the barge with the boat operator to move the barge with crushed stone. The barge move must be timed precisely with the tides, and failure to stay on schedule can mean a 6-hour delay to wait for the next available opportunity to move the barge. On May 11th of 2021, the unloading process took approximately 1.5 hours, during which time complainant did not assist in clearing the overspilled stone on the walkways, which was part of his job duties. Complainant had previously been instructed by his supervisors that he must begin shoveling any overspilled material off the walkways during the unloading process, so that the barge is ready to depart the pier after being unloaded. However, it was only after the material was unloaded and the barge was ready to depart that complainant called an all stop to clear the overspilled stone, crushed stone from the walkways of the barge. Calling an all stop on the job site is a frequent occurrence for the barge crew and is an expectation and requirement of the job when an unsafe condition exists. However, the fact that complainant did not begin to clear the walkways of stone during the 1.5-hour unloading process was unacceptable. And more importantly, after calling the all stop, complainant refused to shovel stone from the walkways. 2 other team members from the batch plant crew, as well as the boat operator, complainant's immediate supervisor, began shoveling the walkways. The project superintendent went to the barge to make sure all team members were helping with the task of clearing the walkways so that the barge could depart safely and on time. The project superintendent asked complainant to help shovel, but he refused to do so and stated that he was busy moving lines. That task was not critical to the job at the time and usually happened after the barge had left the pier and was underway. The project the project superintendent instructed complainant a second time to assist with the shoveling because it was the most important task at the time. Complainant again refused to shovel. The project superintendent had to instruct complainant a third time to stop moving lines and to assist with the shoveling before he did so. Complainant's refusal to follow instructions was unsubordinate and unacceptable. Based on complainant's blatant insubordination on May 11th of 2021 and his previous instances of refusal to follow direction, refusal or avoidance of job duties, and absences from the job site without notification or authorization, the project superintendent made the decision to terminate complainant's employment. And I wanted to respond to a couple of things that had been raised earlier.
That you 10 seconds of your 8 minutes.
Oh, okay, sorry. So the March 18th incident where he claims that he was entangled in lines, that was never reported to Chimbro. And he was not transferred to another boat. He was given the option of sitting out the move if he didn't feel comfortable. But it was the testimony of the boat operator, and I have the testimony here. It's a couple of sentences if you'd like me to read it to you. The boat operator said he was given the option of sitting out that move, but it's his recollection that he actually did get on the barge and move it with them. And I'm happy to answer any questions.
Morning.
Good morning.
So I'm just thinking about the timeline in this case.
Yes.
So according to Attorney Young, what we have is an employee who got a pretty good job review. He got a 5 out of 5, sounds like. And then the investigative report talks about the donut shop incident where he's absent from the work site, right?
Yes.
And then this incident on May 11 where he calls the all stop. And you said in your presentation that, you talked about his worsening attitude,
Yes.
his confrontational. You understand that we don't see every piece of paper,
I
right?
do,
So are there other instances of confrontational, insubordinate behavior that you can highlight for us now briefly?
And yes, and I'm sure that the investigator can do this as well because he interviewed a lot of people, both current and former employees, and they testified to the fact that that Adam was adversarial and didn't take direction well. And it seemed to be the change in his attitude changed once the other boat operator left and he thought he should have the job. And he didn't get it because he wasn't qualified. Everybody else who was a boat operator has graduated from Maine Maritime Academy, and they have a 600-ton Coast Guard license compared to his 100-ton Coast Guard license. And he thought he should get the job, and he was And so his attitude deteriorated significantly once that happened. And the investigator can speak to this, but there were a number of employees who testified about Mr. Shapiro being argumentative and not taking direction.
And I apologize for pressing you on this a little bit,
Okay.
but can you give us any specifics? Like you're talking about, I see in the report it says that there were a number of employees who testified.
Yeah.
And it told the investigator that there were, you know, incidents of his insubordinate confrontational behavior. Can you provide any specific instances of that behavior other than what's in the report?
Yeah, and I can probably pull it from some of the testimony that, but one of the incidents was a former boat operator who is no longer with Chimbro. He testified about him asking him to do something and not wanting to do it because the boat operator was his direct supervisor, because he was a deckhand, and he didn't think that he should have to do the job duties of a deckhand because he thought he should be the boat operator. So when he was asked to do things by the boat operator, he would, you know, give him attitude and want to do something other than what he was being asked to do.
Okay, and this example you just gave,
Yes.
you contended that was after he didn't get this position that he wanted.
Yes.
Before he was fired.
And that was the other thing that this boat operator, who's no longer employed at Chimbro, testified to, was that he was told when he came in that Mr. Shapiro had an attitude, because this boat operator who's no longer there was the guy who was brought in when the vacancy opened up. And so he was told by another boat operator that Mr. Shapiro had an attitude and to be prepared for that. And that's in his testimony. And again, that's a former employee of Chimbro, not a current employee. And then with regard to the OSHA standards, these are OSHA standards, and he didn't want to follow them. It's not just Chimbro's rules, they're OSHA standards, and that's what he had a problem with. He did not want to follow the OSHA standards. And so they actually did make some modifications, because what they did was they allowed them to clip in, clip out, depending on where they were on the boat. Because there were some safety concerns raised, not just by Mr. Shapiro, but some of the other boat crew who felt like there might be some entanglement. So they were allowed to clip on, clip off in different places, but it required going up to a very high level to get modification, because it's an OSHA standard.
Thank you.
You're welcome.
On what date is he passed over for the job? When is that vacancy happen and it's filled and he's?
Must have been April. I'd have to look to see when this gentleman joined.
And when is he terminated?
In May.
In May. So it's just a month or 2 months?
Well, it's 2 months, it's a couple of months.
Yeah.
April, May, yeah.
And did he apply for that job?
He didn't, I don't believe he applied. Well, he wasn't qualified in any event. I think he just thought he should have been given the job.
So apparently I have it wrong. He's not fired for failure to follow the safety harness requirement. It's for the insubordination about
Shoveling aggregate, exactly. So he was, what they needed to do was, he called an all-stop because there was aggregate on the walkways, which is fine. But what they should have been doing is the hour and a half that they were in port, they should have been shoveling the aggregate, and he didn't do it. He waited till the 11th hour to call an all-stop. And then when he did that, he didn't shovel. His boss was down there shoveling, but he refused to shovel. The project superintendent had to come down and instruct him 3 times to shovel the aggregate before he would stop doing what he was doing and shovel the aggregate, even though the boat operator was doing it, his immediate supervisor.
Well, I'll ask him, but I'll also ask you, what does he say was the reason that he was doing some other safety related function and not in untangling other lines?
He was moving the lines around, which didn't need to be done. They were on the other side who were on the other side of the boat. And so he was instructed to, come back to that task later. Let's shovel the aggregate so we can, meet the tide, because it goes every 6 hours, obviously. And he refused to do it, even though the boat operator was doing it, and they brought a couple of other guys on board to shovel it too, so that they could get it done and get it out of there.
Is there a progressive discipline policy, and was it followed?
He was written up. He was spoken to, then he was given a written warning, and then he was actually given another written warning and terminated. You don't have all the paperwork, but
The last one's not a warning, it's termination.
yes, but he was given a warning and terminated. There were two separate documents, but yes, that's what they did.
Any other questions for Attorney Caterin? Right, seeing none, you'll have a minute and a half to come back to you.
Okay.
Attorney Young, you have 2 minutes.
Thank you. Let me turn first to the issue of the last day of work in the aggregate. The boat has 2 sides to it. There was aggregate on both sides of the boat, not just on one side of the boat. Mr. Shapiro was clearing one side of the boat of aggregate. He wasn't just moving lines. The aggregate was on top of the lines and had to be removed in order to be able to let the boat leave from the pier. His supervisor wanted him to clear the other side of the boat. And it is true that Mr. Shapiro said, well, I got to do this side. But eventually, after he did go to the other side and clear the aggregate. I also disagree with Ms. Caterin that there were 3 team members. There was only Mr. Shapiro and another team member who were clearing the aggregate. Let me turn secondly to the issue of the March 26 JHA. There's no evidence in the record that JHA was distributed on March 26th. No emails to the supervisors, no nothing. It wasn't until Mr. Shapiro pressed to do it that it was finally distributed on May the 10th, and it was distributed by him. The date may be March 26th, but it wasn't circulated that day. Finally, I want to talk about the boat operator situation. Yes, there is a dispute about whether Mr. Shapiro should have been classified as a boat operator. He does maintain that he had the necessary license, but in any event, whether he was or wasn't, bottom line, had the license. Shinbro gave him a significant raise because he was in fact moving the boat, and we submitted pictures in our submission showing him at the command of the boat moving the boat.
That's your time.
Thank you. Thank you.
Any questions for Attorney Young? Commissioner Douglas.
Yeah, when was the positive job review? You may have said it, but I think I missed it. What date was that?
I'm sorry, I had trouble hearing your question, Commissioner.
Yeah, my apologies. I'm wondering what date was the positive job review you referenced in your initial presentation?
It was in February of 2021. I don't have the exact date. I apologize.
No, that's fine. Thank you.
Any other commissioner questions for Attorney Young? Seeing none, thank you, Attorney Young. Attorney Caterin, you have about a minute and a half.
Couple of things. So everyone who testified other than Mr. Shapiro testified that Mr. Shapiro refused to shovel. So I mean, across the board, they all testified that he refused to shovel. It wasn't just that he was shoveling the other side, he refused to shovel. And in terms of the evaluation was done by the boat operator. It was not done by the project manager, as Jeff Young said. And the boat operator was not involved in the termination decision. It was the project manager. And in terms of the JHA, on March 25th, 2021, Shinbro prepared, approved, and circulated the job hazard analysis. And I did provide an email from the Director of Health and Safety approving and circulating that to a whole list of individuals, including project managers. So that's just incorrect. And so is there something else that you'd like me to respond to?
Yeah, the job that he didn't get.
Yes.
Did we establish, and I apologize if you said it, did we establish a date for that? Like when he applied and when
He did not apply for it, but it would have been, I believe it would have been April that there was the transition from one boat operator to a new boat operator.
Okay.
So,
all right.
so it would have been around about April, because the boat operator that was there for the final incident hadn't been working there that long when that incident happened. So he hadn't been in the new position all that long.
All right, thank you.
You're welcome. Any other questions?
Thank you, Karen. So we've heard from the attorneys for the parties. We'll next hear from investigator Hurd.
All right, good morning, commissioners. As you know, my name is Colin Hurd, and I was the investigator on this case. So a few things to note. So regarding the evaluation, there was a lot of talk about that, rating a complainant a 5 and a 4 for safety and attitude, et cetera. It's true that that was in the record and it didn't make it into the report. Probably it should have, but and on its face, this does appear to be compelling evidence of pretext on respondent's part. But to clear up the dates, so the evaluation was given on February 24th. And as you'll note from paragraph 3I under the investigator's report for the findings of fact, and the subsequent footnote 3, that evaluation was done before complainant had requested to be upgraded to boat operator. And the foreman testified at the IRC that that's around the time he believed complainant's attitude problems began. Specifically, foreman testified that he believed that complainant's attitude worsened because he was not given the boat operator position after he requested it. And I believe the report says that was sometime, I didn't get an exact date, but it was sometime in March of 2021. I think, so regarding the CAP cards, there was a couple statements made about threats made by the foreman, complainant supervisor about not filling them out correctly. I think the complainant claimed that I dismissed those threats. I don't think they're dismissed. I think footnote 2 speaks for itself, and further qualified by footnote 8. So any issues that foreman and respondent had with complainant were just based on the way that he was filling out the CAP cards, not based on the content of the CAP cards. And then really, you know, I agree that it's kind of a closed case because it all, for me at least, came down to what happened on May 11th. And there's obviously some dispute between the parties about exactly what happened that day. And ultimately, what it came down to for me was the interview that I ended up having with the person named boat operator in the report. I found the boat operator's testimony to be credible, convincing, especially because he didn't work for respondent any longer when I interviewed him. So he didn't really have any reason not to tell me the truth. He wasn't worried about his job or anything like that. And the testimony that he did give confirmed a lot of the testimony that I heard from the supervisor and from the foreman at the conference concerning complainant's attitude issues. From a high level, I think, you know, at an initial superficial look, complainant's case passes that prima facie test because, you know, all the events that occurred are adjacent to the safety concerns that happen, and also in close proximity to the adverse action, to his ultimate discharge. But I think when you zoom into the details, you see that it wasn't the safety reports themselves that proximately caused complainant's discharge. It was these other factors, these issues of insubordination, et cetera. And yeah, that's all I have. I'm happy to answer any questions.
Any commissioner questions for the investigator? Commissioner Douglas.
Yeah, good morning, Colin. First of all, this is an excellent report. Thank you for that. I would ask you the same question that I asked earlier to Attorney Caterin. What we have in the report in terms of insubordination, we have a counseling report based on his failure to be at the job site, and we have the May 11 incident, which is sort of at the heart of this case. And I think Attorney Caterin described one other incident I know you interviewed some employees and they gave you testimony about complainants' alleged insubordination and so on. And I just wonder if you could briefly talk about any specific incidents that you heard about.
So there was no specific incidents in the fact that there was no like, on this date, this thing happened. I think that when the witnesses were testifying that this had happened a while ago, so they were struggling to recall specific events, but the boat operator specifically testified that after, it had something to do with, he believed, complainants not getting the boat operator position. And that believe he testified that he had this general attitude that he felt like he was above doing the deckhand stuff because he felt like he should have been a boat operator, and was just sort of generally combative or dismissive when given instruction by him or by the foreman in those cases. But that is obviously a very generalized thing, but it like I said, it matched what the supervisor and the foreman had both testified. So.
And you agree that this business about him not being a boat operator, this went down in April of 21 roughly? Do you agree with that?
Yeah, March or April. I didn't get a specific date, but they testified at the conference. It was March, and then Attorney Caterin said April. I'm sure it was around there. Yeah.
All right. Thank you, Colin.
Any other commissioner questions for the investigator? Seeing none, thank you, Colin. We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding. Commissioner David.
I'll move that we find that there's no reasonable grounds to believe that respondent unlawfully discriminated on the basis of WPA protected activity, and the complaint should be dismissed.
Second.
Fine.
Been moved and seconded. Any discussion?
My reasoning for that, I agree with Colin that it's sort of a close case when we're sitting here removed about why is this complainant followed. But I have to be impressed with the overall agreement that there is a strong safety culture by Jimbro, and I just can't find that the reason that he's terminated is because of reporting safety violations. When I'm reading the case, I keep looking for something else. Is there a disability? Why is this guy firing, kind of thing? Oh, it's a retaliation case. No, I don't see it's retaliation, even though the proximity makes that suspicious. But overall, I'm impressed with my investigator's clear statement that he finds the report of the operator credible. And therefore I'm going to go with that.
Any other discussion? All right. Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
All right. Findings are no reasonable grounds. We appreciate everyone's participation. Commission will send a letter to the parties and council confirming the results of the hearing.
All right. Next on the agenda is E21-0514, Chad Nguyen versus Walmart Inc. This is a reasonable grounds case, and as a result, we'll hear from the respondent or its representative.
Hello, good morning, commissioners. Attorney Timothy Powell on behalf of the respondent Walmart.
Attorney Powell, you have 10 minutes. Would you like to reserve any of your time?
Sure, 2-minute warning would be great. Thank you, commissioners. So this case involves a grocery order filler at Walmart's distribution center in Lewiston. The grocery order fillers work in the distribution center warehouse, and they're assigned to work in both the dry section, which is essentially room temperature groceries, and the cold section, which is the refrigerated area for things like dairy and meat. The complainant, Mr. Nguyen, submitted a request for accommodation to excuse his work on the cold side of the warehouse due to a medical condition, which he supported with a doctor's note. Walmart denied that request because working on the cold side is an essential function of that position. Walmart advised him that he could apply for other jobs at the warehouse, which he declined to do. And then just 1 week later, Mr. Nguyen submitted another doctor's note, now saying he was cleared to work on the cold side, and Mr. Nguyen returned to work. About a month later, he stopped showing up for work and was separated for job abandonment. And we brought this objection because the investigator's report made several factual and legal errors in arriving at the conclusion of a reasonable grounds finding on the issue of failure to accommodate complainant's disability. So there's three main issues I wanted to bring to the commission's attention today. First, the primary issue here is that the report misunderstands the nature of the grocery order filler position. Mr. Nguyen has argued that there's essentially two order filler positions. There's dry order fillers and cold order fillers, and that he was hired only to work on the dry side. But as a factual matter, that's just not true. Walmart's witnesses were all unanimous and very clear at the fact-finding conference that there is one grocery order filler position. One of the witnesses said plainly, an order filler is an order filler. And there's also only one job description for this position, which states explicitly that work in areas requiring exposure to varying temperatures, extreme heat or cold, is an essential function of the position. Order fillers might be primarily assigned to either the dry side or the cold side, but it's still an essential function of the position that they be able to be assigned to both sides to meet business needs. The investigator's report focused solely on the fact that Mr. Nguyen's job title included the word dry in a few places in his personnel documents. But it really elevates form over substance. The case law is clear. We can't just look to a short job title as proof of an essential function. What matters is what the essential functions of the job are in actuality. And it's clear from the job description and from the statements of all of Walmart's witnesses that an essential function is being assigned to the cold side to meet business needs. So Walmart made the business decision that working in cold environments is an essential function of this position. And under the case law, this determination should be entitled to a significant degree of deference. But the investigator's report has disregarded this and focused instead on this instances where the job title includes the word dry in it. Walmart's not required to accommodate a disability by exempting an employee from performing an essential job function. And Walmart's not required to accommodate a disability by reallocating essential functions to other employees. So it's not appropriate for the investigator's report to speculate that Walmart could have just excluded Mr. Nguyen from the cold side and just assigned other order fillers to do that work. That's just not the right inquiry here. Ultimately, we don't get to that stage of evaluating whether there's a reasonable accommodation or an undue burden here. The inquiry stops because Mr. Nguyen is asking to be fully exempted from performing an essential job function. And under the law, he's not a qualified individual with a disability. And Walmart doesn't need to excuse one of their essential job functions. So the second point I wanted to bring up, when Walmart denied Mr. Nguyen's accommodation request, it did offer to discuss with him a transfer of his position. The HR manager advised him that assignment to the cold side was an essential function of the order filler position. And she said he could transfer to a different position at the warehouse that did not involve working cold temperatures, but Mr. Nguyen refused to transfer to another position. Now he's arguing that Walmart failed to offer him these positions, but it was really his own refusal that foreclosed any further discussion about reassignment. But none of this ended up being necessary, which brings me to my third point. And this is a really important point here that I think was misinterpreted in the investigator's report. So just a week after Mr. Nguyen submitted his first provider certification limiting his work in cold environments, he then obtained a second note from his provider saying the very opposite, that he was fully cleared to work in cold environments, and he did return to work. Now, the investigator's report concludes that this second note was clearly obtained under duress, because Walmart had told him that he couldn't return to his position if he wasn't able to work in a cold environment. But respectfully, that can't be under duress. I mean, employers frequently require employees to obtain medical certification of their ability to perform essential job functions before returning to work. So it just can't be the case that these employees are all under duress to certify their work ability, and that their medical certifications are all suspicious just because they needed it in order to safely return to work. And maybe more importantly, there's no evidence that Mr. Nguyen's medical provider was under duress to clear him to return to work. And we have to respect that medical opinion, that he was fully cleared to return to work. And it's not the place of the commission to just discard that entirely and say, oh, he must have, been under duress to get the certification changed to return to work. So ultimately, we have an employee who requests an accommodation to not work in the cold. And 1 week later, he certified that he could work in the cold, and he did continue working. There's just no argument here that Walmart failed to accommodate any workplace limitation that's now being alleged by Mr. Nguyen. So for these reasons, we ask that the commission find that there are no reasonable grounds to believe that Walmart failed to accommodate the complainant. And I'm happy to take any questions.
Any commissioner questions for Attorney Powell? Commissioner Douglas.
Go ahead. No, I wasn't looking at you. I was looking at you.
Okay, all right.
You're first.
You're senior. Yeah, so Attorney Powell, good morning.
Good morning.
You described the complainant as somebody who was not a qualified individual with a disability. And I just wanted to find out, are you saying that because of the second doctor's note? What's your basis?
Because of the legal definition of qualified individual with a disability is one who can perform the essential functions of the position with or without a reasonable accommodation. And here we have an individual who is saying he cannot perform, he's asking to be excused from an essential function of the position, which is being able to be assigned to the cold side. And so there is no accommodation for him here other than excusing an essential function of the position. And that's what I mean by not a qualified individual with a disability. I'm not arguing, either way, frankly, whether he, had a disability as a medical question. It's more the whether he's qualified, whether he's able to perform the essential functions of the position.
Okay, I appreciate that. And then on the question of undue burden, leaving aside the second doctor's note, which I'm wrestling with, frankly.
Yeah.
He, at some point, I'm looking at page 4 of the investigative report, he provides a doctor's note, basically saying he can't work on the cold side, it exacerbates the symptoms of his disability. And this was provided to HR. He tells the operations manager about the disability, and he's assured that working exclusively on the dry side, not in the cold side, is not a problem. And then for 15 weeks, according to the report, he works only on the dry side, and it doesn't seem to be an issue. So I guess, I've heard what you said during your presentation, but I was wondering if you could just address that specifically. Why is it that doesn't demonstrate this is not an undue burden for your client?
Yeah, absolutely. So first of all, so a couple of points. First of all, our witnesses denied that he was ever promised he could work on the only on the dry side. That's just a disputed fact in this case. But the 15 weeks of him working on the dry side, that was a training period. So he wasn't actually fully working in the position yet. He was in a 15-week training period. He was, he was hired to primarily be assigned to the dry side. And he did his training on the dry side. That just happens to be where they they did his training. But at that point, he wasn't really, there's a mention in the investigator's report about that 15-week period not affecting Walmart's business operations. Well, that's true. It was a training period, just like any person who's in a training period, they're not fully in the job yet. It's not going to affect Walmart's business operations either way while the person's training, because they're not fully present in that position yet. And then my last point would be, my primary argument here is we don't even get to the undue burden analysis here, because the real question is whether this was an essential function of the job. And I believe, and Walmart's, set out quite a bit of evidence that this is an essential function of the position. Walmart's made a business decision to make this position both dry and cold side. And therefore we don't even get into an analysis of whether it is an undue burden on the business to excuse this cold side requirement.
Thank you.
Commissioner David.
Is anybody hired for dry side only?
No. So the witnesses spoke to that at the fact-finding conference, that this is, as one of the witnesses said, an order filler is an order filler. We have to have people who work on both sides, just as business needs arise. We can have someone that's primarily assigned to the dry side, like Mr. Nguyen, but when there's a need for people to be on the cold side to fulfill orders, they need to have people ready to jump into the cold side and do that work as well.
You've already identified that there is this sort of ambiguity about some of the paperwork referring to a GO dry. What exactly is the onboarding paperwork? What does he sign and when? And does that paperwork, is that in the record, and does that indicate the requirements to work in various temperatures and humidities and conditions?
Yes. So there are some documents that the investigator and the complainant pointed to, some onboarding documents that state under job title, I don't know exactly what it is, but it's kind of coded language, and it includes the word dry. It'll say GO dry or something like that. But what we contend is really the operative document is the one job description for all grocery order filler positions. And Mr. Nguyen did, electronically acknowledge that agreement. The complainant has pointed out that there's a signature line that doesn't bear his handwritten signature on it. That's true, but there is another document below that included that shows an electronic acknowledgement of that job description. And yes, that job description for the grocery order filler position explicitly states that work in extreme, varying temperatures, heat and cold is an essential function of the position.
Is it correct that there's a difference in pay for the other warehouse jobs that he might have applied for when he was told that they couldn't accommodate his demand for dry only?
Yes, that's correct. So the other warehouse positions that were available were at a lower pay rate. But as I set out in my objection, that the case law is pretty clear that if there is no other available position for which he is qualified, which there was not, because he was stating he was not able to do the essential functions of the grocery order filler position, that it's the next best thing. It can be a reasonable accommodation to bring in to reassign someone to a lower pay grade, can be a reasonable accommodation. But again, I think we don't even get to that analysis here of a reasonable accommodation and what accommodations are available, because we don't have a qualified individual with a disability who's able to perform the essential job functions.
Yeah, but that's potentially the explanation for him going back and manipulating the doctor to change the note, because he wants to stay with the higher rate of pay, right?
Clearly, he preferred to stay at the higher rate of pay of the grocery order filler position. Yeah, and understandably so. But we have to respect then that medical certification. So he comes back, a week later after submitting his initial certification, he comes back with another certification that says he's now cleared to work. I mean, Walmart has to respect that and allow him to return to work. And so we just don't see here how he was ever denied a reasonable accommodation when ultimately what we end up with here is he's cleared to work on both sides, and he does return to work on both sides.
And I want to be clear, the doctor's notes are dated, are they? That's a question. And what are the
Yes.
dates of the two notes?
They're correct. That's correct. They are dated. Yeah. So we have a March 1st, 2021 is the providers, they filled out the accommodation medical questionnaire form. That's March 1st, 2021. And then March 10th, 2021. So 9 days later is the new certification that he is cleared to work on both sides.
So there is no doctor's note indicating he has a disability when he's hired in September.
No, so that's another thing that the complainant has contended is that when he started work, he provided a doctor's note to, I think, potentially the training manager. That witness all the witnesses denied ever hearing about this accommodation request until the February-March request made the following year.
And there is no such note in the record.
We haven't seen it. Yeah, I'm not aware of it.
All right, because that was my question about the dates, because as I read the report, it said that he provided a note when he was hired.
Correct.
And you did, the respondent denies that, can't find the note, and has witnesses saying we never saw it.
Correct.
Okay, thank you.
Commissioner Ashby?
So forgive me for asking really basic questions. You may have already covered this, but what exactly does the grocery order filler do?
Yeah, so my understanding, I haven't personally seen them do this myself, but it's within the warehouse at the distribution center for Walmart, and they're filling I believe online customer orders that are made. So they're a customer makes an order for a certain group of groceries, and they're going through the warehouse and assembling that order. They're also doing other things they're also stocking the shelves, and so there's some driving of moving pallets around, driving trucks and in the warehouse, things like that.
All right. So although you say that the respondent didn't really have apparently any knowledge of his request that he be required only to work on the dry side, do you agree that for the first, as the fact finder found, for the first 15 weeks of his employment, he only worked on the dry side?
That's right. Well, I dispute the word work because he's training at that point. But yes, he was only on the dry side, and he was training, learning how to do things. All the things that we were just talking about. So
if he's scampering around the warehouse filling the orders of customers, it'd be an amazing coincidence, wouldn't it? If for 15 weeks all of the orders that he received and had to work on all came from the dry side. I mean, you're saying that no one who was training him knew that he was restricted to the dry side.
Oh, well, when employees are working in one side or the other, that's where they're assigned for that shift or that day or whatever. So, a customer order could come in with both dry and cold, orders. Right. But they'll get, that'll get separated, farmed out to the different sides. And, so there's employees that are working, they could spend their whole shift working on the dry side. They're not necessarily running back and forth throughout a shift.
All right, that helps me. Okay, so there is a dry side shift and a cold side shift.
Well, there's assignments, yeah. So you can get assigned. So what could happen is the complainant or any other grocery order filler could be assigned to a cold shift, as business needs arise. We're down a person today. We need someone from the dry side to be assigned to the cold side. That's the situation that can occur. And
all right, well, that helps me understand, forgive me, that helps me understand paragraph G then at page 4 of the fact finder, that one day toward the end of these, 15 weeks of not ever being on the cold side, he was assigned to a shift on the cold side. And that was a problem, as I understand it, from the complainant's point of view.
Right.
Well, how can you say, in light of all of that, how can you say that it's an essential function of the job that a person work on the cold side. I mean, it's not a crazy accommodation to say you're just going to be the guy who always works on the dry side shift. They did it for 15 weeks without batting an eye. How is it an essential function of the job that he work exclusively on the cold shift on a given day? Isn't that really more about Walmart's preference? It's an essential function of how we've structured things, perhaps, but isn't an accommodation exactly that? A request to restructure things to accommodate a person's inability to do that.
Well, so a couple things. First, that was the training period, and it kind of distorts things here. It'd be cleaner if we could talk about, what happened when he started working, which was he was primarily assigned to the dry side, but occasionally assigned to the cold side, which is what that's the typical course of things for all grocery order fillers. But Walmart has made this business decision to do this, and it's entitled to a significant degree of deference. We don't just get to decide what we think is a better way for Walmart to operate. They've decided it's most efficient for us to have grocery order fillers that can perform both functions. That allows us to operate more efficiently, and we can reassign people as needed to fill in on the cold side when there's a gap there. We can reassign the cold folks to the dry side when there's a need on that side. And so as I keep saying, my primary point here is that I don't think we get to the reasonable accommodation or what's an undue burden on Walmart. I don't think we get to that part of the analysis because because we're talking about a person who's asking to be fully excused from this essential job function of being on the cold side. He's not asking for an accommodation to allow him to work on the cold side. He's asking to be excused from that job requirement. And that's the real issue.
Okay, thank you.
Any other commissioner questions for Attorney Powell? None, you'll have about 2 minutes left when we come back to Attorney Beard.
Yes, good morning. I'd like to save
your time.
Yes, I'd like to save 2 minutes, please. So, good morning, commissioners. The investigator here didn't substitute her own judgment for Walmart's business judgment. She properly performed the role of the MHRC here in evaluating evidence. The role is not simply to defer to whatever Walmart says. The facts in this case are simple. Chad Wynn applied to work at the Walmart distribution center in Lewiston. He told Walmart that he had asthma and needed to work only on the dry side of the warehouse. He was hired explicitly to be a dry order filler and told that it wouldn't be a problem, that he couldn't work on the cold side, and he worked only on the dry side for more than 3 months without issue. Walmart then decided to stop providing him with that accommodation and started sending him to the cold side, where he suffered from a serious asthma attack and could barely breathe. He then went through a formal accommodation request process, again, worked only on the dry side for at least 2 weeks while his accommodation request was pending, and then Walmart denied his request. He was forced to ask his doctor for a new medical note so that he could return to work and earn a living. He tried to work on the cold side, he tried to make it work, but it caused serious problems for his asthma, and he eventually had to leave. Walmart asserts as fact that Mr. Wynn saw and signed a job description for a general grocery order filler position. Mr. Wynn has specifically denied this, and Walmart has produced no evidence to show it. Walmart relies on a document where they've essentially stuck 2 different things together. There's a description that he did not sign for grocery order filler, and then there's a page that states that it's for a job title of grocery order filler dry with a position title of order filler dry, and that is what he signed. And notably, while Walmart stuck these 2 documents together for purposes of preparing an exhibit for the MHRC, those documents are not consecutive or linked in any way in Mr. Wynn's official personnel file that he received from Walmart. And I can show this document if it would be helpful sort of at the end of my arguments here. Throughout this case, Walmart has attempted to ignore the glaring fact that it specifically hired Mr. Wynn to be a dry order filler. It has continued to try to ignore that in its objection. None of its briefing and none of its witnesses have been able to explain why all of his paperwork, not just some, says dry order filler, when they claim that's meaningless and Walmart assigns all order fillers interchangeably. That argument is contrary to Walmart's own documents. Walmart has failed to produce, as far as I know, a single document that shows Chad being referred to as a general order filler. The investigator's report properly summarizes this point. The exhibits to Walmart's answer, attachments to our reply to Walmart's answer, they all show Mr. Nguyen being hired as a dry order filler. So while Walmart's witnesses claimed in the IRC that all order fillers are the same, as the investigator correctly found, that simply isn't credible, given that they signed training and orientation documents that all referred to Mr. Nguyen as a dry order filler. Just as sort of an aside, even on the grocery order filler job description, working on the cold side is not listed as an essential function. It's listed under work environment on the job description. The essential functions are all things that Chad could perform. These include organizing the warehouse, stacking empty pallets, fulfilling store orders, maintaining freight integrity and inspecting freight for damage. Those are all things that he did. He performed those essential functions on the dry side. And now Mr. Nguyen doesn't have to rely only on his job title to show that Walmart reasonably could have and did accommodate him in not assigning him to the cold side. Walmart doesn't contest that Mr. Nguyen worked on the dry side for nearly 4 months without issue before it decided to stop honoring his reasonable accommodation. Walmart says this was a training period, so it doesn't count, but the training was doing the job. You know, this isn't a job where you have to study manuals for months before you go do it. The record shows that during this period, new employees were completing orders and being rated on how they did. They were performing the job. Also, even after that training period, when Mr. Nguyen's reasonable accommodation request was pending, he was assigned to work only on the dry side because he had told them he couldn't work on the cold side. And Walmart has not shown in any way that that caused it an undue hardship. Walmart's witnesses were asked about that period during the IRC, and none could identify any issues that were caused by Chad working on only the dry side during that time. In the IRC, Walmart's witnesses attempted to justify not accommodating Mr. Nguyen by saying other employees would get resentful if he weren't sent to the cold side and they were. This doesn't make the requested accommodation an undue burden. The report analyzed this correctly. You know, sometimes the ADA, the MHRA, requires employers to treat people with disabilities differently. Excusing Chad from an occasional rotation is a minor restructuring of his position. That would be a reasonable accommodation. It doesn't cause an undue burden. Walmart also claimed that there would be some minor reduction in flexibility of the workforce, and that also makes it an essential function that he has to be sent to the cold side. Again, this is the purpose of the ADA and the MHRA. They require employers to provide reasonable accommodations. The gears of industry are not so all important that they can't be slowed or altered in any way so that we don't leave those with disabilities behind. And in looking at whether taking one employee out of this rotation to be sent from the dry side to the cold side, whether that would cause Walmart an undue hardship, you know, we're not without guidance here. The MHRA requires that we look at the overall financial resources of the facility or facilities involved, the number of persons employed at the facility, the effect on expenses and resources, the overall financial resources of the company, the overall size of the business, the number of employees. We're talking about Walmart here at a facility employing dozens of order fillers. Of course, removing one of those from an occasional cold side rotation wouldn't cause an undue hardship. Regarding reassignment, Walmart's own witnesses stated in the IRC that they didn't offer reassignment to Chad. During the IRC, the human resources manager, whom Mr. Nguyen had talked to, specifically stated she had no recollection of talking to Mr. Nguyen about a transfer. So this is something that Walmart keeps saying in its briefing. It's simply not true. The human resources manager who was actually involved in this said, no, I don't remember that. The only thing I talked to him about was an unpaid leave of absence. Chad certainly wasn't required to accept an unpaid leave of absence as an accommodation when these other positions were available and they weren't offered to him. Regarding his return to work, the investigator got this right. She used her common sense here to recognize that Mr. Nguyen had to ask his doctor to let him return to work. He had to earn a living. He tried to make this work. He only made it a few weeks before he was forced to quit because Walmart wouldn't grant his accommodation and his health wouldn't allow him to continue to work on the cold side. Mr. Nguyen explained in his sworn affidavit that ultimately he had to quit. The cold side was worsening his asthma. And
that's 8 minutes.
okay. I'm happy to answer any questions that the commission has here.
Commissioner questions for the council? Commissioner O'Brien.
Thank you. One of your last points about the doctor's note, the second doctor's note, saying that he had to work, but I'm a little concerned about duress, the supposed duress. Can you flesh that out a little bit of why the second note said he could work?
Sure. Yeah, I mean, this was Chad's job. He'd worked there for months. He talked to his doctor. He went through the process of requesting a reasonable accommodation. He did all of that right. Walmart refused to provide the accommodation. Walmart then put him out on unpaid leave. So essentially there was no way for him to return to work without going to his doctor and telling her, listen, I need you to clear me. I need to go back to work. And that's what they did.
Okay, thanks.
So that, I mean, just to clarify, he was not offered a transfer to other positions. He was not offered anything else. He was told he could apply to work in the grocery store where the pay was less. And he was put on unpaid leave. So he was left with essentially no options. If he wanted to return to work, this is what he had to do.
Commissioner David.
Attorney Beard, you just said that he was offered other employment at a lesser wage, which is not saying that he couldn't earn a living.
No, well,
it's a higher paying job, right?
No, I mean, so first of all, it was the job he was in. He was performing the essential functions of the job. So the ADA does not require him to go apply to a lesser paying job just because Walmart wanted him to do that. You know, that is not what the law required of him here. And he, again, to push back on what Walmart has said here, he was not offered a transfer, which again, that could potentially be a reasonable accommodation. All he was told was, you can go apply for these worse jobs. And rather than do that, he tried to stay in the job that he was hired to do.
You said, I believe that you said that for 14 weeks, they accommodated his reasonable request. Did I write that down correctly, is what you said?
I think it was 15 weeks, but yes.
For 15 weeks, they accommodated his reasonable request. I understood that he didn't make the request until March.
So that's what Walmart claims. Mr. Nguyen
have a request sooner than that?
Sorry, I didn't catch
Do
that.
you have a request made sooner than that?
We don't have the document because Mr. Nguyen gave the document to Walmart when he started. But he has explained in his sworn complaint to the MHRC that when he started, he provided a note. He explained to Walmart that he needed this accommodation and that he spoke to the operations manager and was assured that it would not be a problem. And that was all in September when he started. He didn't have to go. Walmart didn't make him go through a sort of the same formal accommodation request process at that time. He then worked for months only on the dry side. It wasn't until later that Walmart said, no, we're going to start sending you to the cold side, that then, you know, he had to go through the formal accommodation process, which Walmart denied his request.
Okay, so it is important to your argument to say that he made a written request and we don't have it. He gave it to Walmart and it has not shown up. but it is important to your argument because you said that he made, that for 14 weeks, they accommodated his reasonable request. So you're hanging your hat on the fact that there was a request. And it's just that we don't have it.
I don't know that I'm hanging my hat on that. I ultimately don't think that changes the legal analysis. I do think that's true, and I think it's important. But even if he hadn't made the request initially, he worked as a dry order filler for months without issue. He then made his request, provided support for it, and Walmart denied it. So maybe that's semantics, but
And you said that he was hired explicitly to work only on the dry side. What, in your view, is the hiring paperwork?
So I can pull it up. I don't know whether that's okay in terms of MHRC process. It's stuff that's in the record.
But it's not the document that Respondents Council says includes the language about having to work on the coal side.
Right. So there's documents that I submitted with our reply to the MHRC that show the position he was offered was a dry order filler position. The position he accepted was a dry order filler position. When he showed up for work and there was an orientation, it said his position was dry order filler. All the training he did, it said his position was dry order filler. So all of the documents say that was his position.
So, Attorney Beard, I mean, I'm struggling with the fact that you say all the documents refer to being a dry order filler, and Walmart says there's no such thing. And you say there is.
I'm going to point you to paragraph 5 in the analysis section, which talks about what the documents are. An offer letter, all the training observations that got filled in, and the certification all have the caption that it's for a geo dry.
Okay. All right.
I mean, Commissioner David, my response in that point is I think Walmart is trying to cover for itself here, and that its position that its witnesses took at the IRC were not credible.
The other thing.
Can I move us off this?
Yeah, I'm not going to ask anything more about that. I am really troubled by the two doctor's notes 10 days apart. We are told that we're not looking behind the doctor's notes, and we take those at face value. And you're saying that the doctor was under duress, or that he manipulates the doctor? It really strikes me as troubling.
I don't know that I'd say it's either of those things. I think as the investigator recognized, Mr. Wynn was under duress, and he asked his doctor for help, and this is how his doctor could help him.
Any other commissioner questions for Attorney Beard? All right, seeing none. Attorney Powell, you have 3 minutes left. Feel free to use less than that if you'd like.
Sure. I get the suggestion, yes. So a bunch of things to respond to, so I'll try to keep it brief and hit just a few of them. So first of all, this mention by complainants counsel about an accommodation being given to him and then withdrawn, it's just not the case. I mean, we have, like you were just talking about, there's no documentation of any requests being made in September when he onboarded, and in fact, the witnesses, I'll deny him ever asking for this accommodation. The reality is Walmart has a formal accommodation process, which he went through, but he did that in February, March, started the process in February, had a certification March 1st. That's the accommodation request that we're talking about here. That's the first time Walmart knows about this request not to work on the cold side. The issue of the grocery order filler position and the signature on it. I mean, this is the problem with electronic signatures. It's hard on paper to show that someone signed something, but there's documentation that there's an electronic acknowledgement of the grocery order filler position. Walmart has one grocery order filler job description. It's the only one. And respectfully, counsel for complainant mentioned that there is no statement that working on the cold side is an essential function of the position. That's just not true. I can read from the document right here under this section, work environment. It says working in the following environment is necessary to perform one or more of the essential functions of this position. And it lists a bunch of environmental conditions. One of them is works in areas requiring exposure to varying temperatures, extreme heat or cold, and or wet, damp, or drafty conditions. It's clearly set out as an essential function of the position within the job description. The complainants counsel was mentioning, talking about an undue burden analysis here. And I know I keep hammering this point, but we just don't get to an undue burden analysis because we have, we know what the essential functions of the position are. Walmart's made this business decision to have grocery order fillers have this essential job function of going to the cold side. And the law is clear, we don't have to excuse someone entirely from performing an essential job function, nor do we have to reassign other people to do it. As simple as it may seem to be, that's just not the analysis here. We don't just reassign other people to perform an essential job function. And then the last thing here, I think the commissioners have picked up on this issue of the changing the changing medical certification. It is concerning and it's strange. And I have to imagine, what kind of doctor what doctor would certify that someone is?
Attorney Powell, that's your time.
Okay. Thanks. Thank you, Commissioner.
Questions for Attorney Powell?
Yes, Attorney Powell, I just want to come back to this essential function issue. Because well, let me ask it this way. Does it the fact that he worked for 15 weeks without doing the cold storage, isn't that relevant under the First Circuit's analysis of this question? And I'm looking at your letter here, your submission, and you cite Jones v. Walgreen Corporation. Didn't the First Circuit in that case engage in a fairly lengthy analysis of what people actually did on the job? Isn't that true?
Yes, that's right. And I think what I submit is this 15-week period we're talking about was a training period. We admit that he was assigned to primarily be working on the dry side. That's why his onboarding documents, say GO dry. The intent was for him to be primarily assigned to the dry, but he needed to also be able to perform the functions on the cold. He did his training on the dry side. That's correct. But once he started his job, he was getting routinely assigned to the cold side, as he talks about. That's why come February, after he finishes his training, he starts getting assigned to the cold side. And that's when he submits his formal accommodation request. Because in actuality, outside of the training window, the position does regularly require, assignment to the cold side.
Thank you.
Any other commissioner questions for Attorney Powell? Seeing none, Attorney Beard, you have 2 minutes.
Thank you. Yeah, just 2 points. Walmart here keeps returning to, we don't get in any of this other analysis because we're just looking at essential functions of the job. But as Commissioner Douglas just pointed out, these occasional assignments to the cold side clearly were not an essential function of the position. Mr. Nguyen worked for months without having to go to the cold side. Walmart's witnesses at the IRC, when they attempted to explain why it was an essential function, simply failed to do so. Their reasons are, sort of general business efficiency, and those simply don't overcome the requirement to provide reasonable accommodations. Second, just one final point on the medical note. I think it's important to recognize here that all came after Walmart violated the law anyway. The failure to provide a reasonable accommodation had already occurred. They'd already denied the reasonable accommodation. What followed was simply Mr. Nguyen trying to deal with the fallout of that. So again, happy to answer any other questions.
Any other questions for Attorney Beard? Okay, seeing none, we've heard from the parties, and next we'll hear from Investigator Leyva. You're still muted.
Now can you hear me okay?
No.
Perfect.
Well,
Good morning. Good morning, commissioners. So I've heard a lot today about a couple of things. First, the grocery order position itself. A lot of the documentation that I received from respondent explicitly specified that complainant was hired to be a dry grocery order filler. At the IRC, when I pressed the ops manager about it and asked repeatedly why his paperwork said dry, if he had been hired for both, the ops manager did end up saying that he was hired for the dry department. And based on that, I, went with the respondents and with the the ops manager answer and the documentation that the respondents provided to go with the dry order filler position. Now, as far as the doctor's notes and requesting the actual reasonable accommodation, when complainant was hired, he really believed that he was only going to be working on the dry side. So until he got assigned to the cold side and had a real concern for it, he didn't apply for a reasonable accommodation. It was only at that point that he thought, well, I should, bring this in and make that request. And then that request was what was denied by Walmart. Other than that, I don't have very much to add. Everything else is in my report, but I'm happy to answer any questions.
Thanks, Maria. Commissioner Douglas.
Yeah, good morning. Good morning. Excellent report. I just want to follow up on something Commissioner Davis said. I'm like him, I'm very troubled by these two doctors' notes. And I'm reading your report. You say that it was clear from the record that the second note was obtained under duress. I'm just going to say this directly. In my experience, doctors don't just say, well, I said you couldn't do it before, but now you're having a hard time, so I'm just going to reverse myself 10 days later. Do you have any insight into how he convinced his doctor to issue this second note?
I don't have insight into that. And that was actually not a question that I asked. Based on the way that I was presented the facts, he was offered a leave of absence and an open leave of absence if he couldn't work on the cold side. And so based on that, he decided that he had to go and ask his doctor for a different note.
Okay. All right, thank you.
Mm-hmm.
Any other commissioner questions for Investigator Leyva? Seeing none, thank you, Nooper. We've heard from the parties, we've heard from the investigator. This time we're looking for a motion. There are two proposed findings. Take them together or separately? Commissioner O'Brien.
Well, I would take I would separate them. Again, take the low hanging fruit. I would move there are no reasonable grounds to believe that Walmart retaliated against Chad Nguyen for engaging in MHRA and or WPA protected activity, and these claims should be dismissed.
second.
Okay. Been moved and seconded. Any discussion? Commissioner Ashby.
I have great affection for you, Commissioner O'Brien, but I'm going to vote against your motion. So, the suggestion that the second note somehow changes things is a good argument, but we'd be naive to think that we really can't get our doctors to say almost anything. I think the proof is in the facts of what happened, and I don't think it's disputed that when this fellow worked on the cold side, his asthma made it so that he could not work. That's what's the controlling fact regarding his medical condition for me. With respect to the whether or not discrimination occurred, I think in order to be consistent, the commission should rule in favor of the complainant here. 2 months ago, we decided a case against a statewide healthcare provider who said that a nurse's essential function of her job was to be able to lift 50 pounds. And nonetheless, we found that when they did not accommodate her continued employment because intermittently, very occasionally, the prospect that she might have to lift 50 pounds came up. We ultimately rule in favor of the complainant. And I think that's this case here. This fellow was, it was clear to the employer that at least, well, maybe not clear. It is more than likely, more than an even chance that this employer knew that he could only work on the dry side, and they worked him on the dry side. I had a vision when I asked questions of the attorney for the respondent that the grocery order filler scampered around the store, picking stuff up from the cold section and the warm section in order to fill our online orders. But that appears not to be true, that there are whole shifts for folks to work on one side or the other. And that this fellow, it was quite easy to accommodate his need to work only on one shift or one side of the store. That's not, I don't think it's an essential function of the job to work on the cold side of the store. And I don't think it's unreasonable to accommodate his request to only work those shifts. So that's why I'm going to vote against your motion.
Jeff?
Yeah.
Julie's motion was on the second recommended finding of retaliation.
Oh my God,
So
I'm
you
so
can
embarrassed.
still like
I'm so
it.
embarrassed. Well, you know where I land on the first one. All right, I'm with Julie. Julie,
Okay, we'll take
Julie,
that
real
argument as
excellent
read when we get to
motion.
the-
I'll remember it.
Yeah, all right. So, any other discussion on the second recommended finding? We're doing things a little backward today, all right.
Wow. Why didn't somebody stop me earlier? That's really
You
embarrassing.
were on a roll.
It was eloquent.
All right, so on the second recommended finding that there are no reasonable grounds to believe that Walmart retaliated against the complainant, it's been moved and seconded. If you are in agreement with that, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay, so do I have a motion on the first recommended finding?
Yes, I'd like to make a motion regarding.
I wonder what it will be.
All right, go ahead, Jeff. You're muted.
I don't want to shock anybody, but I move that we adopt the recommendation of the investigator that there are reasonable grounds to find that the respondent discriminated against the complainant on the basis of his disability when it denied his reasonable accommodation request, and that conciliation of the claim should be attempted in accordance with the act.
Do I have a second?
You've heard my argument.
Great. Moved and seconded. Any discussion?
Yeah, please.
Go ahead, Commissioner O'Brien.
This is a little tricky for me. I go back from the issue of the doctor's note, but then I agree with you, Commissioner Ashby, the issue when you brought up the scampering around. The fact that there appear to be two separate fillers, as you will, I think you've persuaded me, Commissioner Ashby.
Yeah, I was just gonna say that, I don't agree that this was an essential function of the job. I mean, I've just been looking at that Jones v. Walgreen case while everybody was talking, and First Circuit engages in a fairly lengthy analysis of what people actually do. And here's on the job, not just the job description. Here's a person who, for 15 weeks, whether he's in training or otherwise, is not required to work on the cold side. And I just found the investigator's comments to be convincing in that regard as well. And so I'll be voting for the motion.
Any other discussion? Seeing none. Oh, yep. Commissioner David.
Yeah, I find it a very difficult case. I don't want to overstate it, but I am really troubled by the two different doctor's notes and the requirement that we credit the doctor's notes, and therefore the remaining the state of the evidence is that there is no reason that he can't work on both sides. I was prepared to vote against the motion. It seems to me that I'm unclear about the onboarding paperwork really is. The description is that they have to be able to work on both sides. We have different visions of what we think we're talking about. Two of the commissioners are talking about running around the store to fill orders. I understood this to be a warehouse requirement and a whole shift. And then Walmart is saying they're paying people for the arduousness of occasionally being signed to the unpleasant conditions of the coal side. And this employee says, I want those wages, not any other job. The thing that's gonna tip me to saying and voting for the motion, the way it currently stands, is that I find this right smack on the dividing line of equally probable either way in terms of how you convince a jury.
Any other discussion? Seeing none, the motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
All right, the findings here are reasonable grounds on the first recommendation and no reasonable grounds on the second. We appreciate everybody's participation, and the commission will send a letter to the parties and council confirming the results of the hearing. Commissioner Ashby, could we have a short break?
Yes, thank you.
5 minutes?
Yeah.
We'll do 5 minutes. Hello, are we ready?
You're unmuted.
Yep, yeah, we're ready.
Perfect. Next on the agenda is E 22-0072. John Argenti or Argenti, I'm sorry, versus the town of Ogunquit. And this is a no reasonable grounds case, and therefore we'll hear from the complainant or his representative.
Is it Argenti or Argenti?
Argenti.
Argenti, all right. So Mr. Argenti, you have 10 minutes. Do you want to reserve any of your time?
I'll try to reserve at least 1 minute. Good morning. First, I want to thank the commission for your time in considering this case and others. I also want to thank the investigator assigned to this case for all the work she put into analyzing information from both sides and for being extremely helpful with questions and concerns during this process. The main reason I'm here and plan to continue pursuing justice and a remedy for what occurred is because the consequences of what the respondent did are ongoing and have already led to tragedy. Today, I would like to review some of the facts of this case one more time publicly. In March of 2021, it was announced that the respondent would be becoming the interim town manager by July 1st. Also in March, I had submitted to the town a list of case law related to the obligation a municipality has to provide protection to members of the public it invites to use its recreational area. Some of the relevant language included the following. Number one, quote, according to the court, a municipality is obliged to furnish an adequate degree of general supervision to its invitees to park and recreation areas. End quote. I would argue that it is reasonable to compare this obligation to furnish an adequate degree of general supervision, end quote, with paying sufficient wages to attract and retain enough quality lifeguards. Number two, quote, moreover, when a defendant knows or should know that a condition on the premises poses an unreasonable risk of harm to patrons, the defendant has a legal duty to take whatever action is reasonably prudent under the circumstances to eliminate or reduce the foreseeable risk of injury, end quote. Trying to increase pay rates using a budget that was already approved by the voters to amounts that were barely competitive with dishwashing jobs in the town of Ogunquit struck me as being reasonably prudent under the circumstances to eliminate what was a foreseeable and announced risk of injury to the public. On May 15, 2021, the respondent became the interim town manager and my boss. I submitted new pay rates for the assistant captains on May 21st, aiming to help retain them and their experience. In response to an email about those rates from the HR consultant, the respondent immediately inquired about how to demote me. On June 4th, we met in his office with the town HR consultant about my unease working for him. In this meeting, he went out of his way to bring up that there was a great job market out there for someone like me. The HR consultant went from saying she felt I should be salaried, that had been discussed earlier in the year, to joining the manager's theme and volunteering unsolicited that she could help me with my resume. This was all very demoralizing. It was also at this meeting that I first learned that the pay rates for the assistant captains were not accepted. When I asked what rates would be acceptable to the respondent, there was silence and then a comment that he would discuss this at another time. An email obtained by the Freedom of Access Act later showed that the respondent intended to provide 0 pay increases to lifeguard staff in 2021 at that time. In the weeks that followed, I tried several times to meet with the manager by asking him at his office. I also sent a couple more emails trying to explain my safety concerns for the upcoming season with context and history. The main concern was not having enough staff, especially not having enough experienced quality staff to keep people at the beach safe. This was not hyperbole or an abstract feeling of concern. It was born out of 2 decades of experience, including seeing people come close to death, up close and personal during incidents that were a result of inadequate staffing. After not being able to meet with the manager or hear from him about my concerns, I submitted pay increases and initial rates for all staff on June 21st to ensure they were paid for the prior training week, which had already started. The week went by and there was still silence from the respondent. After sending an email that weekend, he appeared to be angered by my suggestion at the end of the email that perhaps that I would be willing to meet with the select board chair present. He said he would meet me later in the week. The next morning, after the fire chief went to the manager's office, supposedly to see where his head was at on our behalf, the respondent abruptly called a meeting with the chief and I and informed me that the chief was now the lifeguard captain and would be appointing assistant captains as he saw fit. I could stay as a lifeguard. I tried in vain to convince the respondent to reconsider this abrupt decision, given the context of his tone and overall behavior during and prior to this meeting, including past history. It was clear to me that he wanted me gone while taking care not to be too explicit about it. Furthermore, after I refused to go along with this abrupt demotion, the The respondent proceeded to search for justification for his action ex post facto, including talking with the HR consultant and town treasurer, looking for dirt on me. My reputation within the town.
Hang on, just.
There's something wrong with
Yeah, the camera is.
Yeah, it said something about the default microphone.
Camera.
Oh,
Now we're back.
could you just?
Jeff, can you hear us?
Heard him.
You can, okay, all right,
Sorry, it was just the camera.
Again, yes.
okay.
Not be heard.
Sorry to interrupt,
No
Mr.
worries.
Argenti.
Can I stop the time?
Yep.
Permanently sullying my reputation. After the assistant captains told the chief they would not work for him after what he had just done, the respondent sought to meet again the next day. He tried to put a bow on his actions, pretending as though the day before had not happened. When I told him not to patronize me at the end of that meeting, I was abruptly dismissed, fired, discharged, what have you. I never resigned, nor was I given an ultimatum, as was later said in response to this case, saying that I could not finish the workday if I didn't accept the new arrangement. Instead, I was threatened that if I went to the select board meeting that night, I would no longer be in good standing. His own standing seemed to be his concern, not me, the other employees, nor the safety of the public. In the days and weeks that followed, the respondent continued spreading rumors, along with at least one select board member. Both the respondent and the chief made comments related to my age, including the chief telling one of the assistant captains that lifeguarding was a job for those in high school and college, and then it's time to move on. It was that comment by the chief that led this assistant captain to resign in protest that evening. If this case was restricted to looking at snippets of what the respondents said and did, pieced together neatly, their argument that there was no causal link between the adverse employment actions and retaliation and my attempts to sound the alarm / whistle on danger to the public might hold water. The evidence, however, demonstrates there is such a link. Furthermore, the respondents' own comments about age and their differing treatment of me compared to two younger individuals who took my place show my age was a determining factor in the respondents' treatment of me, including the denial of a promised raise and demotion to an entry-level position in my 20th year with the town, with only the possibility of being chosen as an assistant. That is in the evidence. Subsequently, a much younger individual with no experience in Algonquin has been given a salary position to do significantly less work than I used to perform each year. Taken as a whole, I believe there's reasonable grounds to hold that unlawful discrimination occurred based on suggestive comments and discriminatory treatment by the respondent. Further, there is a direct causal link between my good faith reporting to the respondent of potential violations of the law and conditions jeopardizing the health and safety of people at the beach and the adverse employment action taken against me for it. I never heard of the WPA when I was trying to share my concerns with the respondent, nor ever thought I'd be in this position. I submitted just a portion of the evidence I have to the investigator, trying to impeach the credibility of the respondent in their response to this case and in previous public statements. There was much more, and I hope to have the opportunity to present this evidence in a formal setting. Thank you.
We'll have about 2.5 minutes. Any questions for Mr. Argenti? Commissioner David.
Mr. Argenti, your basis of saying that there's unlawful discrimination is based on age. That's the complaint that you made, correct?
Well, I had two. I guess one was for retaliation, and then one for age discrimination.
Okay. Focusing on the age discrimination, it does not seem that in your presentation you've described the political situation, the turmoil, your advocacy for safety, for adequate pay, all of that kind of thing. But none of that indicates a discrimination against you based on your age.
That's probably true. I mean, I did put this together pretty quickly recently, but in my submissions, I did try to provide more evidence of that. And you know, not being a lawyer, admittedly, my understanding of the law might not fit into protected activity or protected, age discrimination. But the comments from the respondent to not only one of the former lifeguards, but to some citizens that summer, combined with just how I was treated, again, especially in that June 4th meeting, it was just imagine you're sitting down, you worked somewhere for 19 years and your employer says, there's a great job market out there for someone like you, and, hey, we'll help you with your resume. It's just bizarre. And contrast that to how much younger employees who had no experience or very little experience were then rewarded with, same pay rate that I was making in year 20 at age 38.
In regards to that younger employee, he's already employed, right? I mean, they're going down the chain to find somebody to.
In one case,
to be
yes.
the chief or the leader or whatever.
In one case, yes. In the other case, no. So somebody immediately promised a job who was from one of the respondents' hometown and was brought in, and he's now in charge. He was basically, put in charge ahead of everybody else who was already there.
Thank you.
Any other commissioner questions for Mr. Argenti? Commissioner Bryant.
Just, first of all, thank you for your advocacy for safety and for the pay. I'm not an attorney either, and I think most everyone in this room is, except for us. So I appreciate that piece. But a real basic question, if it's in the record, do you work just at, what is the beach? Is it just one beach, and how many lifeguards are?
Yeah, so it's a Gunko Beach. I mean, there's different, like could call them sub beaches, like different names we have for portions of the beach. It's about 1.3 miles of sandy beach, wraps around like a kind of river bend. There's like a tidal river, and then there's one beach across the river on the marginal way. There's like a rocky coast. So there's about 8 stations any given day, especially peak season. There's maybe 15 to 17 lifeguards on duty any given day. So the lifeguard, my position was, at least the last 8 years I was there, I was a lifeguard captain, basically in charge of all those employees. And there's like one station where usually the lifeguard captain would work and kind of oversee the entire beach from that like nerve center, if you will.
Any other commissioner questions for Mr. Argenti?
Yeah, just really briefly, the demotion described in the documents, the way it's described in the investigator's report, it seems like it's a demotion, almost like a name only, right? I mean,
Yeah.
You were told you could still run the beach as you saw fit. Do you agree with that, or?
No, well, no, I mean, that's what was said. Like, I don't know if you got to read my submission, but if you look at the transcript, I mean, it was clear, the fire chief is not a lifeguard captain. You can stay as a lifeguard. He'll be appointing assistant captains as he sees fit. And I just don't see how any person in my position could have then, even if that story changed the next day, like taking that seriously. It was pretty clear that first day what was happening. Like, you're no longer in your position. You might be chosen as an assistant captain by this fire chief, who's now the lifeguard captain, who we barely know, who doesn't know anything about, lifeguarding. There's no precedent for a fire chief in the town of Algonquin, having that type of administrative control over personnel and things like that. Just not the case. And so that first day, it was pretty clear to me what was happening. The next day, the respondent acted like that. He didn't even acknowledge the previous day because things were kind of blowing up. The assistant captains were like, we're not going to work for this fire chief. And word was trying to spread around. So I think, in my opinion, he called me back trying to dampen the fire for him, not necessarily taking back what he did. Yes, the second day, was he saying things along those lines? Yes, but like I said, at the end of the meeting, I was like, don't patronize me. It was just patronizing to me because I felt like it wasn't even acknowledged what happened the day before. I wasn't like, what, I lost my cool yesterday. He was just trying to almost like, I guess I hate to use this word, but gaslighting. And so I said, don't patronize me. And that's when he said abruptly, so you can go home. I mean, I took that as a termination. I texted, I submitted to the, and as evidence, to a friend of mine, as soon as I left the building, I was like, I just got fired. I never said I'm resigning. He never said, and I have evidence of this, that, if you don't accept this change, then you have to leave, you're done. Even that wasn't presented to me. It was an abrupt, you're going home. Maybe he thought, I don't know what was in his mind, but that's what happened.
Yeah. All right, thank you.
You're welcome.
Any other commissioner questions for Mr. Argenti? Seeing none, thank you. You'll have about 2.5 minutes when you come back. Attorney Smith?
Thank you.
10 minutes. You want to reserve any of your time?
No, thanks. I'll see how far I get.
So good morning and thank you, commissioners. Again, my name is Tyler Smith and I am here representing the town of Gunkwit. Just at the beginning, I'd like to observe that the investigator's report in this case was very thorough and very well done. My understanding is that in your commissioner packets, you don't necessarily see all of the evidence that is submitted with respect to a particular charge. And what I will say is that the record in this case was voluminous and it was difficult to follow. And it included a lot of information that was not really relevant. A lot of post-resignation, political turmoil type related issues that really have no bearing on the facts. And the report did a very nice job of cutting through that and really getting to the heart of the matter, and in our view, correctly determining that there are no reasonable grounds to find that age discrimination or whistleblower retaliation occurred. Just to go back to some of the facts, historically, in the town of Ogunquit, the lifeguard service was under the guidance of the fire department. That meant that for most of Mr. Argenti's employment, he reported to the fire chief. And this really is an undisputed point. It's one that Mr. Argenti himself acknowledged in some comments that he submitted to the commission as part of a select board meeting in a video. Now, that reporting structure did change in 2018. And the reason for that change was that at that time, the complainant and the then fire chief were having some communication problems. The relationship between them was poor. And the town manager, who was new at the time, but a very experienced town manager, new to Ogunquit, took the prerogative to change things and have the complainant report directly to her. That fire chief left not too long after that, and then Ogunquit had an interim fire chief. Now, again, to 2021, there were some additional changes. As the complainant noted, an interim town manager was brought in. The prior town manager was retiring. And in addition, a new permanent fire chief was being hired. And as indicated in the documents that were submitted by both parties and noted in the investigator's report, the town was looking to increase efficiency by reducing the number of department heads that report directly to the town manager. So at this point, the new interim town manager decided to return to the historical practice that had been in place for a long time. That is, having the lifeguard service operate under the fire department. Now, to accomplish this under the ordinance, it was necessary to give the lifeguard captain title to the new fire chief. The reason for that is some of the materials indicate, I think actually submitted by the complainant, the lifeguard captain is listed as a department head. So to have the lifeguard captain report to, to have the person who's running the lifeguard service report to the fire chief, let me back up. So in order to have that happen, to have the lifeguard service report to the town manager, the fire chief had to be given that title. Now, it was clear that the complainant's core responsibilities were going to be the same. He was going to be paid the same, but he simply was not going to have the captain title. It was expressed to him in these two meetings that the town wanted him to continue. They wanted him to try the new reporting structure. And it was actually indicated in his reply statement to our position statement.
Unmute's not me talking, it's listening, right?
It was stated in the reply statements submitted by the complainant that they brought up me creating a title of my choice and running the beach, whatever that means. That is from the complainant's reply to our position statement. In the end, however, the complainant decided that he could not be a part of this change and resigned from his position. A political controversy brewed, and the senior remaining lifeguard after that is the one who went into the position that the complainant was going to have. Now, the investigator's report correctly determined that there are no reasonable grounds of either age discrimination or of whistleblower retaliation. The idea that the town did not want to compensate someone of plaintiff's age is belied by the fact that the person who assumed the complainant's position after his resignation was being paid the same wage as the complainant. Nor is there any evidence that the decision to change the reporting structure had anything to do with age or that it was pretextual. And then finally, with respect to the resignation, the investigator correctly determined that this was a resignation. The town manager could have easily allowed complainant to simply walk out of the room when he asked if he should go collect his things. But instead, they urged him to stay. And as the investigator noted in her report, even after the town manager was repeatedly emphasizing, "You're not fired, you are still here," he kept saying things along the lines of, "I think it's time for me to go," strongly suggesting that he was making the decision to leave employment. Now, with respect to the Whistleblower Protection Act, the investigator found that there was no protected activity here. And the statement of disagreement does not really argue anything to the contrary. Instead, all we really hear are general comments about how safety would be improved if we improve or increase the rate of pay for assistant captains. The statement of disagreement did not address that flaw. And finally, even if there was a protected activity, the changed reporting structure, as we just discussed, was not pretextual. One final point to make as well, the complainant made a point about this email from late May about how in response or after an email where he raised the rate of pay issues, the town manager was talking about changing his position so that the lifeguard captain would be the fire chief. Well, what's important about that is when you look at the investigator report, she points out in section 3D that the issues about safety were not raised until June 4th through June 28th. So after the town manager had already raised the issue about reassigning the lifeguard captain title. And obviously the town could not be retaliating against Mr. Argenti for things he had not have said. So for all these reasons, we'd ask that the commission approve the investigator's report. Thank you.
All right, you'll have also about 2.5 minutes when we come back to you. Any questions for respondents' counsel? All right, seeing none. Mr. Argenti, you have about 2.5 minutes if you have anything else you'd like to add.
All right, thank you. So I'll try to respond to some of the points that Mr. Smith made. In terms of like the last one he just made about how that I didn't submit any concerns until June 4th. Well, as I submitted to you and also to the investigator, I had submitted case law back as far back as March. I mean, I could, if I could, I don't want to keep you all day up, but I could show you emails going back like years. I mean, this was, but especially that year, showing, expressing my concern. And again, I wasn't doing it like to be dramatic. I was like genuinely concerned. It was post-COVID. We were losing a lot of staff because it's such a competitive economy, especially like in Agunquit in that area. But a lot of veterans would have loved to come back, even work making less than they could have elsewhere, but it needed to be respectable pay. And this had come up in budget meetings where some of the committee members were like, you should be paying them $25 an hour a minute. I was just trying to get to $18 an hour starting pay. And so, and the key point about this, that last point is that, yes, in May, the town manager said something about making me an assistant captain. And then after I submitted my concerns, all of a sudden, as you can see in the transcript of that conversation, it was like, maybe you'll be an assistant, the fire chief is in charge, and he'll be appointing assistant captains as he sees fit. I mean, was that just to make me feel bad one day? And then the next day, oh yes, yeah, you're still in charge, just come up with a title of your choosing. I mean, I think it's important to look at those two things next to each other. I mean, what was the purpose of saying that the day before? Was it just, anger fueled, or what was the point of saying you're a lifeguard, the fire chief will be appointing assistant captains as he sees fit? I'm there 30 years old, significantly older than most of the other staff. And now it's like, yeah, maybe you'll be an assistant captain. And then the next day, well, yeah, you can come up with the title of your choosing. I mean, imagine being in my position and this whiplash of what's going on. I was in that position for 8 years, never had a complaint. In fact, he even said in that first meeting, you've done a great job. So what was the purpose of all this? And if it was just going back to regular order as they claim. I mean, why? What the timing is just doesn't make sense, doesn't add up. And it's not true that we were always under the fire chief as the respondent claims. I mean, it was very loosely affiliated for like a period of 15 years. And in fact, my entire tenure, I was doing the budget. I was doing all administrative functions. There's maybe a 10-year period where the fire chief submitted budgets for the lifeguard service because the lifeguard captain in that 10-year period just didn't want to get involved. They didn't want to get in politics, whatever. And it was a flat budget all 10 years. So, and I think I'm out of time.
Any other questions for Mr. Argenti? Thank you very much. Attorney Smith, you have 2.5 minutes.
Thank you. Just a quick point on the wages issue. And again, I appreciate the commissioners may not have this in front of them, but in our initial position statement, Exhibit 2 was a list of comps that the town had procured throughout this process when it was looking at Mr. Argenti's proposal to see what other towns were paying. It looked at Old Orchard Beach, it looked at Wells, it looked at York, and it looked at Kennebunk. And the rates that were paid in those towns were either commensurate with or excuse me, the rates being paid in Ogunquit were either commensurate with or superior to the rates in all of those adjoining communities. Thank you.
Any other questions for Attorney Smith? Okay, seeing none, we've heard from Mr. Argenti and we've heard from Respondents Council. We'll next hear from Investigator Leyva.
Hi, good morning again, commissioners. I really don't know what else to say about this case. That's not in my report. I focused mostly on the boilerplate language of the laws in this case and what happened based on the record I had. And based on that, my decision is, I think, fairly in-depth and well-written in the report, but I don't have anything special to add that I would need to make you guys aware of.
Questions for the investigator?
Only to say that I agree that your report is in-depth and well-written.
Thank you. Thank you.
All right. Seeing no further questions, thank you all. Thank you, Newber. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There are two recommended findings. Thank you, Ed. You can take them together or separately. Anyone?
I'll move to take them together and move that we find that there's no reasonable grounds to believe that there was age discrimination and no reasonable grounds to believe that there was retaliation against the respondent. The complaint should be dismissed.
Do I have a second? No, I don't have a second yet.
Second.
Second, okay, thank you, Jeff. Moved and seconded, any discussion?
Yeah, so on the age discrimination claim, and I just want Mr. Argenti to understand that I get that, you know, this is a difficult situation. You worked there a long time and you did a lot of work and you're sort of handling all this administrative stuff. I get that. And I get your angst over all of this. I do, I understand it. Unfortunately, the claims that you have here are based on discrimination on the basis of age. And there's very little in the record to support that. There's the wage issue, which I think has been addressed, you know, that the young people that were left were paid the same as you. And I'm just struggling to find anything else in the record to demonstrate discrimination on the basis of age, unfortunately. So just wanted you to understand that from me. So thank you for your presentation.
Any other discussion? All right, seeing none, the motion is to find no reasonable grounds on both findings. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Right. Findings are no reasonable grounds on both recommendations. We appreciate everybody's participation. The commission will send a letter to the parties and the council confirming the results of the hearing.
All right, well, I'm gonna call the next case and then I'm going to recuse myself.
Right.
The next case is E22-0322. That's Joshua Kenny versus the University of Southern Maine. This is a no reasonable grounds case. And as a result, we'll hear from the complainant.
Yeah, well, it's not, this isn't our case now anyway, so.
Oh, it isn't?
No.
So are they coming
Could you
back to
please
you?
mute yourself?
Maybe they disabled you to hear it.
Well, we'll hear from the complainant or his representative, and then I'm going to recuse myself.
We have Mr. Kenny either in the meeting or I know he's not in the room here.
Well, I don't know if city manager is.
I think city manager was for the last case.
And or for the next case.
Chelsea, do you mind just checking the room next door to see if there's anything there?
Kenny is who I'm looking for?
Yeah.
Madam Chairman, do you have an updated agenda? Because some of these cases aren't on the sheet that you gave. Is there a current agenda?
I know everybody else who's in the Zoom meeting is our staff or the city managers. So I think that Mr. Kenny is not here. Generally, when the complainant in this case is not at the meeting, we would adopt the findings of the investigator's report. There is there are two recommended findings. Do I have a motion? Commissioner O'Brien.
I would take them together and make a motion that there are no reasonable grounds to believe that USM discriminated against Joshua Kenny on the basis of age and or disability, and there are no reasonable grounds to believe that USM retaliated against Joshua Kenny for engaging in WPA protected activity, and the complaint should be dismissed.
Do I have a second?
Second.
Any discussion? Seeing none, the motion is to find no reasonable grounds on both findings. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay. The findings are no reasonable grounds. We appreciate Investigator Bosheng being here, and the commission will send a letter to the parties and council confirming the results of the hearing.
You caught me off guard. I left I was going to have lunch. I'm really glad
In the next case, I know that the attorney for the city of Eastport had let us know on Friday that he had been scheduled unexpectedly for a case today and had asked us to send him an email or a text message when the case before his was being called. So we have sent him a text message, but I'm not sure that he's had time to receive it. So I think it might make more sense for us to go to the last case and then to take PA 220361 last.
Well, here's a question. Is the complainant here for the next case?
Well, that's a good question. Is Mr. Wong here? There's nobody in our waiting room. The only person in our room is the respondent in the last case. I don't see anybody on Zoom besides the city manager that I don't recognize. I don't believe I have had any emails. Somebody saying I can't get in. No. Okay, so.
No.
We still have one more case after this. Yeah. Yeah, we have to at least vote on the other two cases. So again, since the complainant is not here, we would, in this case, generally adopt the findings of the investigators.
So you're on
report.
6, right,
I'm-
Wong versus Eastport.
Yes.
Yes.
There's one recommended finding. Do I have a motion?
Sure.
Commissioner Douglas?
Yeah, I'll move that we adopt the recommended finding that there are no reasonable grounds to believe that the respondent city of Eastport discriminated against complainant Jimmy Wong in public accommodations due to his race, national origin, and or ancestry. Charge to be dismissed, consistent with 5 MRS 4612, section 2.
Do I have a second? Great. Been moved and seconded. Any discussion? Seeing none. The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
All right, findings are no reasonable grounds. We will send a letter to the parties and council confirming the results of this hearing.
All right, then last on the agenda is H 23-0281. That's Kim Pound versus Eugene Gutierrez and 97 Wausau Street LLC. That is no reasonable grounds case, and we should hear from the complainant or their representative.
Again, I believe the complainant is not here. I still don't see anybody in the Zoom who I don't recognize. So, again, we would adopt the recommendations of the investigator. In this case, there is one proposed finding. Do I have a motion? Commissioner O'Brien.
I'm on the right one. I would move there are no reasonable grounds to believe that Eugene Gutierrez or 97 Wausau Street LLC discriminated against Kim Pound based on national origin, and the complaint should be dismissed in accordance with 5 MRS 46122.
Do I have a second?
Second.
Any discussion? Seeing none. Motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
All right, the findings are no reasonable grounds. We appreciate you being here, Mr. Gutierrez. The commission will send a letter to the parties confirming the results of the hearing. I believe that completes the hearing agenda. Chelsea, will you text Attorney Mahar and let him know?
So we just voted on the grounds, I spoke, you know, no show.
And city manager, were you here for the Eastport case? City manager, I'm not sure where you're the city manager of. Can you unmute yourself, please? Great. All right. Were you here for the Jimmy Y. Wong versus Eastport case?
But it's not on mute, right?
Yep, I can hear you fine.
It's not even showing us on there. How do you get all us on there? The picture thing that you get off of?
Can you hear me?
The participant has enabled closed comprehensive circle.
You have, where the heck is it?
Oh. I'm guessing we're going into a case and I can't get into it.
Well, you shouldn't be able to caption it either then. I think they would block captioning too.
What's the?
Should I say no?
I'm saying no.
How do I respond to that?
No, I don't know.
On your microphone is how you respond.
Yes. This,
I'm not very good at this, but
I don't know what's happening. We can hear you, but I don't think you can hear us. No, we can't. What about if you go back to this thing up here? Or something? I don't know.
I don't.
I'm just asking them via the chat if they were here for the East Court case.
Click on that.
Right?
He said going into our case.
I'm gonna.
Yes.
Hey.
Oh, that's based.
Come over
I wonder if you move that over onto there, whether it opens the screen here or is it?
No idea, but
and,
no, you're not. That's
he was listening right on, but now the speakers are not working. We cannot hear what they're saying. I looked at.
they can hear us, but we can't hear them.
I would think that he must have somehow muted.
Okay, I guess I gotta type answers.
Now, do you mind if I put you on speakerphone?
How do you type it in, I wonder?
I don't know. He's gonna.
I've got Johnny on the phone.
Yeah, go ahead and find out what.
And where should he go, Johnny? Now.
Look at the invitation.
Hi, dear. We're having technical difficulty. We can't hear you guys, but you can hear us.
Okay, along the bottom. Okay, I'm along the bottom, Johnny. Still there?
Yeah.
Okay.
Oh.
Something there for the mute.
Okay, so does he leave the meeting then?
Yeah, the mute is off.
Yes, I'm on the. I'm. Okay. You see me? I am waving.
Speaker side.
It's on.
Can you hear me?
I'm on the green, in the green shirt.
It's up to 70% and.
Right. Yeah.
Is there a volume on the other one?
Okay.
What's that icon?
It's the chat.
Okay, so we'll leave the meeting.
That's the answer. I thought it might be our mic.
Okay, thank you, sir.
Okay, I think I was talking to the
Bye-bye.
host.
You guys can leave the meeting.
I can leave the
They
meeting.
don't need you.
Thanks, Johnny.
Thank you.
How do I get out of the meeting?
Hang on, let me see. It should have been.
If I gotta go back in or?
No, you're done. They don't need you.
Okay.
Okay.
So there should be something.
So there should be something that says leave. Leave the meeting right here.
Okay. Well then. So we're all done with the hearing agenda.
Pursuant to 1 MRS Section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
All right, it's been moved and seconded. Any discussion? Seeing none. If you vote yes, you're in agreement. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Okay, now we have to do our thing. Getting into the breakout room.
You can imagine that I have sympathy for folks that commit Zoom-related faux pas, who seem like oblivious of what's going on.
That one was.
Dear to my heart, those people in Eastport.
At least we hope they were from.
I know.
Yeah, or Gunquit. I don't know.
Maybe.
All right. progress.
I can't hear you, Barbara. Or Ed, or anyone.
Can you hear us now?
I can.
We had some feedback, so I just needed to make sure everything was.
All right, I move that we adopt the recommendations of our council that we litigate case number H23-0084, but that we not litigate case number PA 22-0144. For the reasons stated in the memorandum.
All right, it's been moved and seconded. Any discussion? Seeing none, if you vote yes, you are in favor. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Great. Okay.
I move that we appoint Kit Thompson Crossman to the position of Executive Director, Public Service Executive 2, and set their remuneration and pay grade at pay grade HE 38 step 3.
Second.
It's been moved and seconded.
Shush.
You
It's
do this
been
one.
moved and seconded. Any discussion? Excellent.
Well, I think it's no secret that we hold Kit in very high regard, that they are doing a fabulous job having hit the ground running. It has seemed to be a seamless transition. There are efficiencies associated with making this appointment at this time. It's well within our authority. It's not difficult or challenging at all for me to make the motion to do so. I'm excited about it.
And I enthusiastically support. I had expected some bumps in the road and to be experiencing some problems in going forward after Amy, and they have not materialized. And it's clear that Kit that they're competent, ready, willing, and able, and appear to be excited about continuing on with us. And I think it'll be a pleasure to vote for the motion.
I would say certainly to piggyback on that. Well, ready, willing, and able, we're sure of. So.
Willing also.
Okay.
I was gonna say, the whole thing is for naught if I just lied to them for 15 minutes.
Want to hear from her. Yeah. Well, yeah.
All right.
Thank you.
Unless Mark and Tom also want to join in singing Kit's praises, I'm gonna call the question.
Heartily endorse.
With full
comments
confidence.
With full confidence, the comments made by my fellow commissioners.
Thank you.
Lovely.
And credit to Amy as well for such a smooth transition. She did a lot of work to make sure this happened.
And I was also quite fabulous.
You were also always fabulous. Were and continue to be.
See, come on. All right. If you are in favor, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Julie. Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Oh my God, I'm so tired.
Walker. Commissioner Walker.
I was gonna say Commissioner Mark.
That's fine.
Mark something with a W.
Yes.
Walker. Sorry, I never use your last name,
No,
ever. Great, 5 in favor, 0 opposed. Thank you very much. I, for one, am beyond thrilled.
Likewise.
Thank you.
Congratulations.
Congratulations.
Very much.
Woo! Would anyone like to move to adjourn, or should we just do it?
Let's just do it.
Okay.
All right. Thank you all.
Thank you all.
Thank you.
Have a great month.
You too.
See you, Jeff. Have